stops, no one knows. We're going head into the unknown. Na, 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 na.
We are here in State of Indiana versus Richard Allen. Show that the defendant is here in person with Mr. Baldwin, Mr. Rosie, and I'm sorry, I don't know the lady at your table.
I don't know how to say that lady's name.
Auger.
Okay, this is Miss Auger, Jennifer Auger.
Okay, she's the attorney that entered her limited appearance for digital forensics information.
She did, Judge. And then there was an appearance that was entered a week or so ago that was a general appearance.
And I entered an order on that, and you should be receiving that shortly. It was a confidential order, states.
Would the court... I'm sorry, may I?
No, the state's here by their chief elected prosecutor, Mr. McClelland, Mr. Luttrell, Ms. Diener. Yes, what?
Well, to the extent that it might have an impact on what she can do at the hearing today, I was suggesting maybe we could approach the bench and you could advise us as to the nature of the order, just so that we're not crossing some boundaries that the court's not permitting us to do.
You may approach. I was not aware of a limit. I granted your motion for an expert. She's the expert, apparently, in digital forensics. The limited appearance was for that very limited issue, and then I see a general appearance. I don't know what that is, and I asked for an explanation. I don't have the order. It's not in the file.
Okay.
Because it's a confidential order, so no, I'm not going to...
Well, she's not an expert. She's an attorney.
Well, she was listed as an expert in the field of digital forensics. Mr. Rosie or Mr. Baldwin's request.
Funds?
Yeah, for funds.
Oh, yeah,
And I approve that. No, I approve that. I know she's an attorney, and then...
Yeah.
So she entered a limited appearance for that specific purpose, and then all of a sudden, I see a general appearance. I don't know what that is. I haven't authorized a general appearance. I authorized a limited appearance.
I understand that. Yeah, I was...
So that's...
articulating to the court what the posture was to make sure we're on the same page.
I believe that we are, and I don't know what her role is going to be. I assume it's limited to the digital issues that you have raised in the past.
Yeah, I think that was the original intent. And then, obviously, because of the workload and the late discovery, which we're continuing to receive, which has just been the natural course of things, we felt like we didn't want to be penned in when we got into court with her just being able to talk about the limited issue. We basically just, asked the court to recognize her as one of the attorneys on the case so that she can...
Well, that's something that...
assist us in litigating at this late hour.
Well, then that's something we'll have to discuss, because I haven't approved that.
Sure, that's fine.
I've approved a limited appearance.
I just want to make sure she's not doing something today that you're prohibiting her from doing. That's why I asked.
As long as she's limited to the digital issues, then...
Yeah.
I don't have a problem with that. That's what I have approved.
Yeah, I think that's what the confusion is this, where are the parameters in that sphere also? Because those are terms of art, and we've learned all that in the last couple of weeks as we've, as I've done some discovery in this field. So, I mean, those are just some of the things. We can talk about it when we're finished today. I'm fine with that.
Okay.
Okay. Very good. Thank you.
Thank you, Judge.
All right. The defendant filed a motion for pretrial hearing on April 30th. I set that hearing for today so that we could discuss the issues that you've raised. And before you get into that, earlier this morning, Deputy Attorney General Aaron Ridlin appeared on behalf of the Department of Correction. The Department of Correction is a non-party, and the defense filed a motion to enter a stipulated protective order. I granted that order and sent the order to the clerk of the court on May 2nd. For reasons that I do not understand, the clerk of the court never entered it as an actual order of this court, and the Deputy Attorney General appeared. I provided him a copy of the order. I've had my staff go ahead and enter that order, and it was previously scanned in. I don't know why it didn't go in. But I had my staff then go ahead and enter that order, dated it. It's dated May 2nd. It was entered into the CCS on May 7th. I provided a copy of that to counsel on your tables, so I don't know what the disconnect was, but I did grant it.
Judge, I spoke to Mr. Ridlin in the hallway, and he departed the courthouse because he felt like his business was finished today. So I think we're all on the same page about what we're trying to accomplish.
Okay. So then you'll get a duplicate copy of the order then. Are you ready to proceed with on your motion, Mr. Rosie?
Judge, I am. May I inquire as to, are we dealing with a request regarding the scheduling issues, or are we dealing with the request or joinder for a hearing on the state's motion in limine?
Both.
Okay, well, I guess it's the defense's view that if we're going to address the state's motion in limine, it's their motion. And so they would have the burden of proof to introduce what evidence they need to make their arguments that the evidence should be limited, and then we would respond to that.
So you filed a motion for a pretrial hearing, but you do not wish to have a pretrial hearing?
I filed a motion consenting to the state's request for a hearing on the motion in limine.
Okay. So the motion for a pretrial hearing that you filed on April 30th, you requested a pretrial hearing to discuss scheduling issues associated with the trial, secure the appropriate amount of trial time for defendant Allen to present a full and comprehensive defense, and to address any other pretrial matters that may be necessary.
Very good. I can comment on that.
Okay, well, go ahead.
Judge, obviously we're looking at the trial calendar, and the court had communicated with parties through an email indicating that this trial was going to commence on May 13th here in Fort Wayne, and that this trial was going to end on May 31st in Carroll County. And those dates, in my interpretation of the email, I think you used the phrase "not more or less." They're not flexible dates. Those were firm dates that were going to be adhered to in this case. And naturally, I understand that the court has not been a party to the exchange of the actual witness and exhibit lists because of the way the state and the defense has chosen to communicate. We filed notices that those witness lists were exchanged, but we did not share those with the court so that they would not become public, at least on our side. And so I understand that the court may not have a full grasp in terms of the context of the number of witnesses that will be called and the amount of exhibits that would be introduced. With that being said, I think I shared with the court in the motion that, that I haven't counted them up to date, but I would say that each witness list at this point has over 100 witnesses. And that's probably half of those are duplicated, the other half are not. In the normal course of a trial, I would expect that, only a percentage of those would be called. And so I don't expect the court's going to see 200 witnesses starting next week, but it's pretty obvious to me that the volume of witnesses and exhibits, at least in the opinion of the defense, would require, substantially more time than the 2.5 weeks that's set aside to present evidence. And while with the defense going second, that puts us at a disadvantage, obviously, because we don't know how long it's going to take for the state's case. And so we've got this problem of, okay, if you're going to limit the time that we have to introduce and put on evidence, are you going to split that time in half? Is there going to be some manner in which the court divvies up that time so that there's some equity in the process? I just practically don't think that we can do this in that short of a period of time. And that's even taking into consideration that we're going to be working on Saturdays and maybe into the evening hours a little longer. I don't want to be in a situation where for 2 or 3 or 4 weeks or 2.5 weeks, we're sitting here and we're staring at the clock every minute. And so I'm looking for a practical solution to that. I think the defense is looking for a practical solution. I haven't had any conversations with Mr. McClelland about how long he thinks that it will take to present his case, but I feel like we both have a pretty good idea of the scope of the presentations, and I just don't see that we're going to be able to do it in that time frame. In terms of the law that's applicable, I did lay some of that out for the court. I don't really feel like I need to sit here and make legal arguments. To me, it's more of a housekeeping or a business related matter in terms of how much time the parties would need to present their cases adequately. But to the extent that the law is applicable, it seems to be pretty clear to me that one of the burdens placed on the court is that the court, before issuing any kind of, I'll call them restraining type orders or orders of restraint, where you're setting specific time frames, that the court must be fully aware of the scope of the evidence that's going to be presented and the witnesses that may be called. And that's based mostly in federal law that is trickled down to the state, because that's where you get most of the regulation regarding the length of trials, and the presentation of evidence is in the federal courts. But that law is out there, and I'm not sure whether it's just, I think this case, just because of the kind of the nature of the communications between the parties, which we all acknowledge are, not the most streamlined. At least I acknowledge that, and that's just the way it is, and that's fine. But we haven't had a lot of dialogue about what's ahead. We haven't had a lot of pretrial hearings in terms of motions in limine and things like that. And so I understand that the court doesn't have a really good grasp, at least. I feel like the court doesn't have a good grasp on the scope of the evidence. And so I think it's a little premature to set firm dates without the court having a better understanding of what would be offered up. I think in September or October, we had a phone conversation, and I believe during that phone conversation, we were discussing the January 2024 trial date at that time. And I believe the court inquired to the defense as to what we were thinking in terms of time as far as the trial is concerned. And I believe I'm the one who actually suggested it probably would take us approximately 2 weeks, more or less, to present our case. I still think that's basically true. The words more or less matter a lot in cases like this, when you've got jurors that could be sequestered for long periods of time. You're moving staffs from one jurisdiction to the other, I understand. There's a lot of logistical challenges that are on the court, but I still feel like our position hasn't changed. It's probably going to take us a couple weeks to present our case. And obviously, with the May 13th through May 31st trial setting, with part of that being consumed by jury or how do you say that word?
Voir dire or voir dire.
Voir dire. It just doesn't provide us with the adequate amount of time to present our case. And I'm opining that the state probably is going to feel the same way, but Mr. McClelland and his staff can speak for themselves. So we're just looking for some practical solutions to those problems. And that was the purpose for the order. And so that's the defense's position.
Mr. McClelland?
Thank you, Your Honor. As always, a pleasure to appear before you again today. Judge, we have done what we can to streamline our witnesses and exhibits that we plan to introduce. I'm not real sure how to respond. State doesn't have any objection to the 2 weeks. State hopes to have its evidence done and concluded by the 25th. That still leaves a whole nother week for the defense to present any evidence and any rebuttal evidence and any opining that they may wish to do. That's our best guess with what we've got. Again, we tried to streamline it. We've got it down to about 40 to 45 witnesses, and a handful of those, it's half a dozen to a dozen would be chain of custody type witnesses. We're trying to work through some of those issues with the defense in terms of stipulations and whatnot, but that's where the state's at. State satisfied with the amount of the time the court set aside? That's the only comments I have, Judge.
So what is your request, Mr. Rosie? You're indicating I set this matter at your request for speedy trial. You made your request on March 6th. On March 7th, I set it for trial May 13th to the 31st. And the first time I'm hearing that those specific dates are not adequate is April 30th in your filing?
Yeah, the defense's request is that the court not bookend the back end of this trial to end on a certain date, that being May 31st. That the court understand that the presentation of evidence is just part of what professionals do in a case like this, and that occurs in a natural situation, in a natural setting, and it ends when it ends. And to the extent that there is a need to, regulate those timelines or time frames in a more strict sense, that we would sit down and maybe the court even consider requesting some or issuing an order that might further define the witnesses now that we're getting closer to the trial setting and the discovery is getting closer to being completed, and then make a decision after Mr. McClelland, for the first time today, for example, just suggested he thought they had about 40 witnesses. Well, that's 30 to 40% of the witness list that we received. So that's an indication of how fluid this case is. And so I would ask that the court either consider some further discussions with the parties to further define those witness lists at the end of the week. But at the end of the day, it seems like we're kind of at their mercy in terms of how long it's going to take them to present evidence. And there's also rebuttal evidence that has to be taken into consideration as well. I think those things are not overly predictable, especially in a case like this. We've got logistics in terms of getting experts to and from. Those will cause, I'm guessing, some further delays. And so what I'm asking the court to do is not set an end date for this trial and understand that it's going to take more time. I would ask that the defense be given 15 days of actual trial time to present its case. 15 working days would be the request by defense. And some of that is based on our predictions back in September and October of 2023. And having seen the witness list being modified over the last couple of weeks, because frankly, discovery continues to come in, and that's just the nature of this case. We're taking depots tomorrow, and it is true, Mr. McClelland mentioned that there's some stipulations that we're working on. Ms. Diener and I have been communicating in that regard to try and streamline some things so that we're more efficient. But at the end of the day, I think that we're going to need probably 15 days of courtroom time to put on our case. That's what I'm asking the court to consider and grant.
Well, you understand. Well, maybe you don't understand. Jury Rule 4 requires that I issue summonses to the jury with dates of the trial. The specialized questionnaire that you all approved months ago was mailed to the jurors, and you now have copies of those, hard copies at your request. You all came up and picked those completed questionnaires up. Jury Rule 4 requires that I issue summons to jurors with the dates. Particularly in this matter, the dates that I provided to the jury is May 13th to May 31st. Jurors have been asked to arrange their schedules accordingly around those dates and times. And the rule requires that I mail the summons to them at least a week in advance. I confirmed with the jury office that the summonses were mailed to your veneer on April 19th, which was a Friday, and I anticipate that they started getting those summonses to appear on April 22nd. So I've given the jury the dates that the trial has been scheduled for. And again, until now, I've not been told that you need this amount of time. I can't bookend a trial when I've already told the jury this is what the dates are going to be. You have a remedy? And again, I wish you would have informed the court well before April 30th that you didn't feel that the dates that were selected at your request for a speedy trial were adequate.
May I?
Of course.
Judge, I appreciate that. This was a situation where frankly, the court never inquired with the parties about, what was forthcoming. That request wasn't made that I'm aware of. And, I think that might have helped solve some of these problems. But let's just pose the hypothetical. What if Mr. McClellan and the state's case runs into the 28th or 29th of this trial? So is the court going to allow us 2 days to put on witnesses, and then we walk in one morning on the 31st and you say, hey, at noon, if you're not done, we're done? We all know that that's going to pose a problem that's going to end up causing this case to be retried. There's no doubt about it. There's got to be some flexibility on the back end of this to kind of roll with the punches, so to speak, understanding that there are a lot of moving parts here. So I think under the court's current order, we're at the beck end call of the state. In fact, from a strategic standpoint, you've invited them to put on a more verbose case, which might otherwise chew up our time and not permit Mr. Allen to, offer up an adequate defense. So how are we supposed to deal with that? I mean, I think it's just practically a problem. And I think it violates his Sixth Amendment right to come in here and offer up to the jury a full, adequate, competent, and complete defense. And we're asking the court to reconsider the request for 15 days on our watch. Again, I said this back in September or October. I didn't say 2 weeks for a trial. I said 2 weeks for the defense's case. And I think you even suggested or mentioned that in the email or one of the orders that was issued. And so that's what I said. That's what we're asking for. I think our request is consistent with what we requested in the fall. And I'm asking the court to reconsider any thought to putting a drop dead date on when this trial is going to end.
Well, then you need new trial dates, gentlemen and ladies. That's your solution. I cannot ask jurors that I've already tied in from May 13th to May 31st to extend indefinitely or for another 2 weeks after that time frame. Again, had you informed the court immediately upon receipt of the motion where I granted your motion for an early trial, had you notified me immediately, Judge, these are not sufficient dates, I would have absolutely given you whatever time you needed on the court's calendar. I have no problem with that. I've tried hundreds and hundreds and hundreds of jury trials. I have no problem at all with that. In my belief, 3 weeks for trial was adequate. I'm now being told 3 weeks is not adequate. I have in my hand the April 30th, 2024 defendant's notice of submission of supplemental witness and exhibit list to the state. It's one paragraph. It's a notice to the court that you're exchanging witness lists. I have no idea what you're doing. That's not my job to know what you're doing. That's not my job to micromanage attorneys. My job is to call the balls and the strikes during the jury trial and to conduct an appropriate opportunity for the state to present its evidence and for the defense to present its evidence. Again, had you told me when you got the order granting your motion for a speedy trial that this is not sufficient time, I would have absolutely given you however many more weeks you were asking for. I hear nothing from counsel, nothing at all from either side until April 30th. Your motion for a pretrial hearing, that this is inadequate time, and now you're asking me to do something I cannot do. Under the jury rules, I cannot give you that extra additional 15 days at the end of trial. I can't do it.
So is the court going to divvy up the time equally, the time that does exist?
The court is going to ask you all to be professionals and stipulate to what you can stipulate to. If you're telling me that you're stipulating, and I don't know what chain of custody issues have been arising between the parties. I have no idea what that is. Again, you've been very closed-mouthed with the court about your evidence, what your evidence is. Other than the motions to suppress and the multiple Franks motions that you filed, and the state's responses there too, I get notice of submission, which is one paragraph that lists no information for the court.
May I?
Sure.
There is the the court has sent out, I think, and produced roughly 450 jury questionnaires. My assumption is that we're gonna voir dire in panels of about 50 at a time, I think is what the court suggested, roughly in some of its instructions. One of the things that the court could consider doing is questioning the jurors as part of the voir dire about whether or not they're able to spend more time sequestered to make sure that we can get this trial done that might be an option. And to the extent that the jurors are not able to extend their calendars or their schedules beyond that May 31st date, then maybe they would be struck. I think 450 jurors is going to be more than enough, and I think we can find in that pool people that are willing to stay and serve the interest of justice and their civic duties without burden. So that might be one possibility in resolving this circumstance. I'm still not sure, even under the current schedule regiment, I should say, I'm not sure that I'm aware of how we would present our case again if our time is consumed. You're not telling me how we're going to solve that problem if the state's case takes longer than what they haven't even told you how long it's going to take, except for, well, it might be a week. We're not really sure.
Well, he's indicated 45 witnesses approximately.
Judge, yeah. What the state did is we took the time the court set aside for the trial, and we tried to, well, I guess I'm going to use slang terms a little. We tried to cut the fat as much as we could and streamline this in the most efficient way we could. Now, can't predict what's going to happen and how long the testimony of each witness is going to be. We tried to predict that, and we tried to fashion our questions and our witnesses, again, in the most streamlined way possible, knowing that we were set in that allotted amount of time. And so we've cut witnesses in that respect in order to present our case as efficiently as we can. And so that's what we've done, Judge. And I believe we've around 40, 45. That may be reduced depending on what we can stipulate to. We may have to throw a witness in there if we can't make some stipulations, but we've done our very best to, again, cut as many witnesses as possible while still meeting our burden, Judge.
So your suggestion, Mr. Rosie, is to proceed forward and hope that the jurors that we have summoned can give another 3 weeks, which means the court has made arrangements for jurors for lodging, transportation, etc. You're asking me then to extend that? Well, what if I can't? I've entered into contracts with vendors.
Well, it sounds like the court just invited me to move to continue the case to another date that that's the way I interpreted what you just said a few minutes ago, which would kind of run afoul or run in the face of you having all these things organized. I understand that, that's why we're here having this professional discussion about time, but we're not hearing anything from the state that's suggesting that it's going to take them a week. He's saying we're trying to streamline things. Well, that's not real comforting when you're sitting over here and you're on the receiving end of that, So I'm not hearing anything from the court that's, that's confining the state to any specific amount of time. In fact, it's almost like you're not willing to do that in the context of this, which suggests to me that they could sit there and put on evidence until the cows come home. And I don't want to be in the situation where we just stop one day and we tell everybody to go home and we'll see you again in the fall. We're going to do it all over again. It just doesn't make any sense to me. And I've never been involved in a situation ever. And I understand this is a unique circumstance, but I've never been involved in a situation where a judge set an end date and not only said it's not going to end sooner or later.
Excuse me? Hold on. You've never had a court set a trial date for you?
I've had a court set.
Is that what you're telling me?
Starting dates, but I've never had a court tell us it's going to end on May 31st. No more, no less. Those were the words of the court in this case. I've never had that happen, which is one of the reasons why I filed the motion. And look, we're practicing in different areas of the state. Doesn't mean that what's going on up here is, better or worse than what's going on where I make a living, but that's the reality. That's
a shocking reality, Mr. Rosie. I've never heard any of my colleagues give open dates for trials. I'm surprised that happens routinely across the state of Indiana.
Well,
because in this court and in my experience with my colleagues, you get a trial date. Here's your trial dates, May 13th to May 31st, period.
Yeah, well.
So your experience is vastly different than this court's.
And that's fine. The problem is we have to deal with those things and find some solutions. And I'm asking the court in this case to recognize his right to put on a defense is just as important and, frankly, more paramount than their right to prosecute.
I don't disagree. And again, I wish you had let me know.
And so by pinning us in, it almost seems like I used the word invite earlier. It seems like you're inviting them to make his situation, Mr. Allen's, more untenable. And I don't understand that. I don't understand how it is that the court couldn't reach out to the parties before the court issued the order setting the dates and say, hey, I'm getting ready to issue this order setting dates. 2 weeks going to be enough? 3 weeks going to be enough? A month? I mean, a lot has occurred since September and October when we talked. And so, it seems like to me that why that didn't happen, I don't really care. I know that we're dealing with that circumstance as we're sitting here today. I just want to get the problem fixed. And that's
Well, it happened, sir.
for the court to consider.
Because I don't feel, if I email, my emails end up in pleadings. Obviously, we can't have a 6-way phone conversation. And emails ending up in pleadings is not how I do business. So I do business in written orders. I gave you an order granting your motion. You're now telling me it's insufficient. Again, I don't know what you want me to do. I gave you set trial dates. I've always given you set trial dates. You've never indicated that those dates were inadequate, again, until April 30th. When we sit here now today, so...
Can we have a 5-minute recess, please?
Why?
I would like to speak with my co-counsel here and have a discussion about the business issues, such as scheduling, not here in a courtroom where everybody's listening to us. We've got, 50 staff members in this courtroom, people sitting behind. There's no privacy. And I'd like to talk to him in the hallway about some of the logistics of this so we can solve this problem so that he, Mr. Allen, can put on a defense.
Does the state have any objection to a recess?
No, Your Honor. Might give me a chance to go find a Mountain Dew or a Dr. Pepper.
All right, Jody, you can go off the record. All right, have you had adequate time, Mr. Rosie,
Yes, ma'am.
to have some discussions?
Yes, ma'am.
Okay. I note in your motion for a pretrial hearing as well that you had indicated in your paragraph 15 that this case doesn't present itself to the court as a case of first impression, at least not from a scheduling standpoint. And you are correct in that. I did preside over the case of the state of Indiana versus Bob Leonard, which was a case venued from Indianapolis, Marion County in 2016. I think it was commonly known down in Indianapolis as the Richmond Hills explosion case. That case was set for trial, you are correct, for 34 days with nearly 140 witnesses. What you didn't include in your petition and your pleading is that case was actually tried by this court in 20 days with 161 witnesses and over 2,000 items of evidence. I also tried the state of Indiana versus Cohen Hans Barron, a life without parole, with an individual who murdered his girlfriend and her 3 children. We tried that in 7 days with 36 witnesses and over 200 items of evidence. Bryce Pope was a life without parole case that I tried in 4 days with 2 victims. Dustin Neal was a 2017 murder that was tried in 2023. I tried that one in 4 days. And I tried a death penalty case earlier in my career in 2.5 weeks with 4 victims. So I am experienced in scheduling matters for trial. Gentlemen and lady, again, I've given you the opportunity to consult with counsel and co-counsel to kind of see where you're at and to speak with Mr. Allen. What would you like to do, sir?
Judge, first things first, I'd like to just make a record that we did have a chance to speak with Mr. Allen in the jury room.
Okay.
And I appreciate it. Some sense of privacy in that regard. I would like to note for the record that we have security staff standing next to us when we're talking to him. We're not permitted to talk to him in private. There are 2 gentlemen in there, I'm sure nice gentlemen, sure doing their job, but the idea that there's any confidences that are communicated to our client in this case, it's not true. And that hasn't been the case throughout. It wasn't the case a few minutes ago when we walked in that jury room and had people essentially standing next to us when we were talking. The same was true when I was here a few weeks back, a month or so ago, when we were out in the hall. We were offered up a spot in the corner of the hallway to talk to our client while the security staff stood nearby. And I'm asking the court to consider in the future to allow us to spend our time with some form of privacy. I would appreciate that.
We can certainly take him down to our office and they can talk to him while he's in the holding cell.
Can we do that?
Yes, we can.
Okay. You can do that right now if you want. Speak to him privately.
Well, it's too late. We just had this conversation knowing that we had limited time and I didn't want the court to, we knew we had to get back in here. I asked for 5 minutes, so.
Well, Sergeant Tinkle has informed me that you may speak with your client privately down in their offices.
That ship has passed, okay? I appreciate the offer, but it doesn't make any sense for us to go back in there and talk about what we just talked about. I'm asking the court to consider moving forward that we be given some privacy with our client. Second, what we're requesting from the court today is 15 business days to present our defense.
Okay.
15 business days. We believe that that's the amount of time it would take us to present an adequate defense on Mr. Allen's behalf. Third, to the extent the court is inclined to deny that request, then we are asking that the court, we're moving to lift our speedy trial request, and we're asking the court to give us a new date in earnest when the court can set aside the adequate time that we've requested to present our case. What the state does, that's on them. They can ask for however much time they need, but we are asking for 15 days.
Mr. McLeland? I'm sorry. Were you done?
I'm finished. Mr. Baldwin would like to speak.
Judge, we are filing a second request for you to be disqualified in this case. I have that here. It will be filed by email as well, or by filing. May I approach?
What do you have?
A motion to disqualify you as judge on this case.
Okay. It needs to be e-filed.
Okay. Would you like a paper copy?
No. I can get one when it's e-filed.
Okay.
I have nothing further.
Mr. McLeland?
Judge, in terms of a response to defendant's motion, I guess I'll just focus on the lifting of the speedy trial setting and trial date. Judge, we'll leave that to the discretion of this court. Of course, it's frustrating because we're ready to go on the 13th. We're ready to move this thing forward. But I would leave that part to the discretion of the court. In terms of the defense's second verified motion to disqualify, Judge, it's 24 pages, Judge. I haven't read through it. I don't have any response to it at this point. And so I'll just leave it at that, Judge.
Well, he hasn't e-filed it yet. So when it gets e-filed, you'll have the opportunity to file your appropriate response.
Thank you, Judge.
So you're waiving your right to a speedy trial then?
Yes, at this moment we are.
Okay. And you're asking for 15 business days. I've looked at my calendars, and we were originally set in Carroll County October 14th through the 31st. If you're requesting an additional 3 weeks after that, we can go October 14th to November 15th. Or October 14th to November 15th.
Is the court granting a request for 15 days for the defense to put on its case within that time frame?
If you can't try this case in a month, gentlemen and lady, there's something wrong. I see no reason that this case cannot be tried in 30 days. We will work on Saturday. The schedule that I've previously provided to you in an email some month ago, I see no reason that it can't happen in that time frame.
You don't know anything about this case. With all due respect, Your Honor, you haven't seen a witness list or an exhibit list.
No, I have not.
So I have no idea how you can have any context for what is involved in this case. And the discovery continues to come in because every day that he sits in that hole down in Wabash Valley, there's new evidence that's presented.
So are you.
by the way of 24 hours of video, camcorder video, medical records, psychiatric records. How would you possibly know? We haven't had a pretrial hearing on any substantive issue in this case. You have summarily denied everything we've put on your desk. How would you possibly know how long this case is going to take to try it? It's beyond me. I don't understand how that could possibly be.
I have 27 years of experience on the bench, Mr. Rosie, trying multiple high-profile homicide, life without parole, and death penalty cases. Are you telling me that 30 days is inadequate for the state and the defense to try this case?
I'm telling you that picking an arbitrary number does not make sense. What makes sense is having the parties have discussions, maybe in an open court with a scheduling hearing that would be ordered, about really how many witnesses are coming, really how many exhibits are you putting in, what are your logistical challenges, those kinds of things, and then we can come to some conclusion on how much time it's going to take.
Well, then why don't you have those discussions and let me know that you cannot physically do it in 30 days? I'm waiting.
Because we're not talking. It's probably pretty obvious at this point.
Oh, it's patently clear.
Yeah.
To me, Mr. Rosie, that the defense team and the prosecution team are dealing with each other in written form only.
Email only is the instruction we've been given from the state. And so the line of communication is somewhat broken, and to the extent that those problems could be solved, they could be solved by ordering the parties into a courtroom to have a constructive conversation about scheduling, which did not occur.
Well, we're all here now. Why don't we have those discussions?
Well, we have been, and they're not bearing any fruit. We've made our request 15 days to try this case. We're moving to lift the speedy trial motion. My request is simple. How much time between October 14th and November 15th will be dedicated to the state's or the defense's case? That's what I'm asking.
Mr. McClelland?
Judge, I can't give you a definite day of how long it'll take us to present the case. The burden's on us. When I presented to the court before that I thought we could be done by the 26th, that was taken into consideration the time the court had set aside for trial. That's only taking into consideration how long we think it'll take to do direct examination of the witnesses. No idea how long it'll take for cross-examination with this group. No idea how much cross is going to be allowed, frankly. And so I'm not willing from the state's perspective to say, okay, judge, give us this amount of days to put on your case. What I can present to the court, what I wanted to tell the court, is that we are going to present our case in the most efficient, fast way we can with the time allotted from the court. It is not our intention to take the time given by the court and take up every single day so the defense doesn't have an opportunity to present their case. However, we have the burden, but we are going to take the time the court gives us and do what we can to make it as efficient as possible, not only for the state, for the jurors, and for the witnesses that are involved. We're going to do our best, Judge, but I'm not willing to sit here today and say, give me 7 days, give me 8 days. That's just not something I could do, Judge, because I don't know the extent of the cross-examination of the witnesses.
So, Mr. Rosie, Mr. Baldwin, I will grant your motion to continue the jury trial and order it reset to October 14th through the 15th at 8:30, beginning at 9 o'clock every morning down in the Carroll Circuit Court. Show that you've withdrawn your right for a speedy trial. And while you're all here, do you wish to schedule a pretrial hearing, or do you want to address well, we can set pretrial hearings. And Mr. Rosie and Mr. Baldwin, when the court summarily denies motions that have been filed, it is the court's belief that there's nothing within the pleadings that have been filed that require a hearing. So if you wish to have a hearing on your own various motions to suppress, I would entertain that. When would you like that set?
Judge, while they're looking at their calendars, I'm sorry, Judge, there was some rustling in the background. I didn't hear the dates. October 15th through when for the trial date?
October 14th.
Oh, 14th?
To November 15th.
Okay, thank you, Judge. Apologize about that.
I believe there are two, maybe three motions to suppress that are still pending. I know one I just got and the state hasn't responded to, so you've got your 10 days to respond.
Judge, I could tell you the plan there was I'm sorry, I don't know if it's a third or fourth Frank's motion filed. The state's intent, given that we expected the trial date to start on Monday, was going to rest on the previous responses filed, but
Okay.
the state will take another look at the most recent motion to suppress filed and then draft a response quickly, Judge.
Whenever the court can get it set, Judge, we can look at our calendars, but whatever works for the court.
Well, we were supposed to be available to the court May 21st through the 23rd, so why don't we just set the motions to suppress for then? Does that work for you, Mr. Rosie?
Yes.
Well, we'll set aside 3 days for pending motions, May 21st through the 23rd. So that can be the motions to suppress. I know there was a second one, and I think maybe a third motion to suppress as well as the state's motion in limine that we can resolve at that time as well.
So, Judge, is the court referring with the motion to suppress, you're including the Franks? I think there's 2 Franks motions pending and 2 motions to suppress. Any pending motions, basically?
Not the Franks hearings.
Okay.
Yeah, not the Franks. Just the motions to suppress and the motion in limine.
Okay.
Are there any other pending motions other than the Franks motions that you haven't replied to, Mr. McClellan, that the defense has filed that you want a hearing on?
No, Judge. There's only one Franks, and I pulled it out. It's the 4th Franks motion the state has not responded to. Was going to respond to that orally today, given the short trial date. The only other motion, I think there's a motion to compel, perhaps filed by this defense. And then last night, late in the evening, Judge, I filed a request for pretrial ruling on admissibility. I'd asked the court to consider hearing that on the 21st through the 23rd as well. I don't think it'll take long, but I would ask the court to consider that as well. It was filed late last night. May not have been accepted yet by the court.
It is not. It's not in the...
I didn't think it would.
Yeah, it's not in the file.
It was late last night when I filed it, Judge, so...
What was it? What's it called?
Basically, we want a ruling. We got some documents we'd like the court to review and rule on their admissibility. There's some pretty important documents to the state. They're incriminating statements made by Mr. Allen. And so we'd like the court to review those. I'd like to give them to the court under seal because they are pretty incriminating. And so I would like the court to consider those and give us a ruling on whether or not they could be admissible at trial. I can refile it with exhibits sealed, or I can present those to the court today under seal. I've not talked to defense about that at this point.
You can just give me the sealed documents, but the motion is, again, it hasn't been accepted yet, and obviously the defense hasn't seen it.
There's nothing in the motion that needs to be sealed, Judge. I just didn't attach the exhibit. When I filed it, I wasn't sure of the process to make sure they were sealed, so I just didn't want to file them. But I'd like to present them to the court under seal so the court can consider those in injunction with the IC code that we cite so we can talk about it on the 21st or the 23rd at some point.
Okay, so does the defense have anything else?
Judge, just an inquiry about what's going to happen with Mr. Allen. He's, his movements and location and housing circumstances we're unaware of what those are. What's the court anticipating moving forward? I know I learned in a deposition the other day that he's going to be brought up here. So I don't know so is he going to be in Tippecanoe County? Is he going to be here? Is he going to be back to Pendleton, or?
If you really want to have this discussion in front of everybody, I'm happy to do that. But for security reasons, I don't think that's appropriate, Mr. Rosie.
Well, if the court would be inclined to email us and give us,
I'm not emailing any longer because, again, my emails continue to end up in people's pleadings, and I don't think that's appropriate. So, again, if you would like to have this conversation in front of company, I'm happy to do that. But I don't think it's advisable based on security issues for Mr. Allen's safety.
okay, we can have that conversation in a setting that's more confidential. I'm okay with that.
Thank you. Anything else from the state?
I don't believe so, Judge.
All right, then we'll see you in court. Be prepared, and we'll do May 21st through the 23rd for 3 straight days, starting at 9 o'clock and ending at whenever we end. So be prepared.
In Carroll County, Judge?
I'm sorry?
In Carroll County?
Yeah, in Carroll County. Be prepared on the motions to suppress, the motion in limine, the motion for ruling on admissibility, and that's all I have so far. Oh, and the motion to compel. I'm sorry. All right. Thank you very much. Jody, you can go off the record.
Thank you, Judge.
And that is it. That is that's the shortest transcript we've had. So, what are your thoughts? We lost Rosie. He bounced quick from the courtroom. He was like, "I'm out. Fuck this judge."
I mean, one of the things that kind of jumped out to me, or a couple things, is I don't know if she's just not reading stuff that comes in as filings, or if she just glances at them and forgets about them. I mean, the normal appearance that she seemed completely baffled about for Miss OJ, like, that was filed April 29th, and she was completely clueless about why this person was even in court. Like, did she just not read that motion to appear? And then the other part of that same sort of, in that same vein, is like, Rosie saying, like, we did say that we needed 2 weeks for our case, and she seems to have completely let that slip her mind and thought that doing 2.5 weeks for the entire trial, after you take out the voir dire, like, that was going to be sufficient, when clearly that wasn't ever. Like, these things actually are previously filed and previously discussed, and she just is completely clueless about what's going on in her case.
Well, she doesn't. This was the problem I had with all these communications that were not on the record, which didn't make sense. You can have hearings and they can last 15 minutes and you could still have the damn hearing. But they had all these phone calls, and so this stuff is said. It's the same. That's probably around the same conversation back in October when they were like, yeah, we are going to file our speedy trial closer to, beginning of next month so that we keep the January date. And they all acted like that never happened either. So because there is nothing written that it's happening, so they don't care.
Yeah, and I mean, she's not very, I don't know, not very flexible. Or like at the end there, like, you don't want to have it in open court, discuss like his accommodations or whatever, but you also refuse to do an email. So
right.
Like, then it just gets tabled and to a more confidential hearing. Like, when? Like, you're not gonna be able to organize that with an email. So how is that gonna get scheduled? Like, it's, let me check. Yeah, it's 2024. So how the fuck you're doing anything without, like, sending people emails to coordinate anything is beyond me.
What are your thoughts, Travis?
Yeah, I made a note about the thing with OJ. She does throw out terms of art. She's an expert on digital forensics, and this isn't about digital forensics, and that's not what it was. And just I don't know, she seems to make up her mind, and once she makes up her mind, becomes totally inflexible. They filed a motion for funds to add her to handle the TUI request, because without them saying it explicitly, I don't think Baldwin or Rosie had ever run into trying to depose federal agents and having to go and get TUI requests granted and approved. And Auger, they listed her experience with that, and they asked that she be paid to handle that, and she granted it. And then they got a request that she just be a third attorney on the case. And those first few pages, they're just totally miscommunicating. And well, she's an expert on forensics, and Rosie kind of goes along with that and is not correcting her right from the get-go. And it should have just been really, really simple. Well, Judge, she's not an expert. She's has expertise in getting TUI motions prepared and granted so we could depose the federal agents regarding the telephone data, but you approved funds for her as an attorney. What we filed last week was to approve her to assist in all aspects of the case because of and then lay out the problems. But
And right, I mean, how does she not know that? Because they filed, I mean, there's a motion to appear and add her as a third attorney. Like,
yeah,
I mean,
so,
it was one. Like, I mean, it was one page to read. Like, I don't know how that's not in her mind, and she's baffled by this attorney showing up today.
But she acts like she knows that motion exists. This that she hasn't done anything with it, so she's like, I don't know why this person's even here.
Well, she knew it existed because she had issued an order on it that hadn't been filed yet. And I guess the order said, I don't know why this person is now being sought for a general appearance, and they were supposed to be limited. So, I need more clarification. That's what her order was. And then all Rosie was trying to do is say, fine, I get that. But if we do need her to talk today, I need to make sure she's not violating an order. Whether you pay her or not, that's a different question. But I guess he just figured wait until it came to that. And they, then they jumped into the timing issue. And, it's just nonsensical. I'm wondering why they, if during their discussions during that recess, if they said, well, should we call her bluff or not? And by calling her bluff, it would have been, well, Judge, we're not waiving the speedy trial. We're telling you right now, it's going to take 10 business days. We're going to cut it down. It's going to take 10 business days for us to put on our case. If we reach a point and, because of the state, if they've taken up more than a week and we don't have time to put on our defense, that's where we'll be at. And then, we'll figure out then what we need to do. But we're not going to move the speedy trial, but they may have, with their research and the assistance of others, may not have felt 100% comfortable doing that, and may not have felt like they were on the solidest of legal foundations to do it. So they end up doing this other thing. McClellan never, but it's not uncommon for these conversations to go like this. It's, Judge, we think it's going to take 7 to 10 days for the state to put on our case. Now, of course, That'll vary depending on what the cross-examination is, but we're factoring that in 7 to 10 days. And then, defense, how many days you figure, and then you'll get judge who'll say, well, I'm going to let the jury know you guys are saying 5 weeks. I just don't see how that is based on what the number of witnesses are and whatnot. I think it can be tried in 4 weeks, and that's what I'm going to tell the jury. The thing about the questionnaire and saying what the dates were, that's done in all cases. Every case in voir dire, even without a questionnaire, the judge will say, civil or criminal, the parties have estimated this case will take 5 to 7 days to try, 5 to 7 trial days, or 5 to 8 weeks, or 5 to 6 months. Anyone going to have a problem with that? And then, come up one at a time and, tell me what the problem is. I care for an elderly parent. I have small children at home and no alternatives. I have, whatever it might be. I run my own business. I can't be away that long. That can easily be varied. The fact that it was on the questionnaire is easily addressed. And it's just in the questionnaire we asked, that it was going to be this many days. Other things have transpired since then. It looks more realistic that it's going to be this number of days. So we're going to be asking you if that changes your answer. Obviously, those that put it would be a problem, the fact that it's going to be even longer probably isn't going to change your answer. But if it does, let us know. And, we'll go from there. Let's see. We got Rule 4, notice of selection, jury pool.
Yeah, so I brought that up because this is what she refers to. And then, so at first I was like, once again, here's like my all giving faith. I'm like, okay, well, she obviously knows what she's talking about. So then when I actually went and looked at it, I was like, this isn't like so set in stone like she made it seem. So it just essentially says, like no later than 7 days after the date of the drawing of names from the jury pool, the jury administrator shall mail to each person whose name is drawn a juror qualification form and a notice of the period during which any service may be performed. The judges of the courts of record in the county shall select by local rule one of the following procedures to summon them. And then down here it talks about like this is what it has to include. There's nothing like so black and white that she can't change that. I think she sticks with this whole like 7 days, like, well, because of when the hearing was, that she couldn't change anything based on that they were 7 days away from trial at that point, because this was May 7th, and then the trial, jury selection was supposed to start May 13th. So she's like, I can't send out new ones, but it's not, like I said, the only thing in here that's really even kind of goes to what she's saying is the notice of period during which any service may be performed, which makes me go, what Rosie was asking for then actually could be done, because it's like may be performed, not like these are set in stone dates and I can't make the jury do anything different.
Now, I have heard that the jury rule 4 had also been amended recently, and I'm not sure if anybody knows anything.
I don't know.
That.
But let's also not forget that it really doesn't matter what the rule says or means, that she will do whatever she wants.
Well, I think he was, throughout trying to show, to make it overall look like the whole thing was the defense's fault. Naturally. And, I think tired of looking bad, I would say, overall, this transcript is probably actually the recordings and the transcript, the actual recordings probably going to end up, if they appeal the denial of the second disqualification motion, that'll be part of the record. And, I think the appellate attorneys are going to be arguing, of course, her bias in here. And, the other thing, and I mentioned this before last time, so the June transcript, the hearing a year ago, the issue of the number of days came up briefly at the end, and I said, man, that's the time, if I'm the defense, I'm putting a bug in the judge's ear that because I asked you guys to confirm it, and she talked about setting the dates in January, and it was the same 3-week time period, including picking the jury. And that's when they should have been, well, Judge, we think our case is going to take 3 weeks, so we're probably going to need a total of 5 weeks.
Well, in fairness to that, though, wasn't Rozzy like, yeah, I think he said something to the effect of, well, we're probably going to need more than that, but he also hadn't gotten a hold of all the unrevealed discovery that came out in the August-September period too. So there could have been a lot of reticence, to push it when they were already kind of starting to be on bad footing with her.
Travis made a good point that the more we get transcripts, we can actually figure out is that there's these little instances where the defense has the opportunity to correct things or say things and doesn't do it.
Right. That's true. That was important that you pointed that out, Travis. That's true, Catastrophe. Yeah, that's very true.
And then the biggest thing in this hearing is, and she had them, and she knew it. I sent out the notice of trial setting.
Yeah.
And you don't start complaining about the time until whatever it was, a few days before, the 30th or something. I can't remember how long they had it before they filed an objection. On March 7th, page 11. On March 7th, I set it for trial, May 13th through the 31st. That's 21 days.
Well, that's not unusual that they budget out the time for all these trials. For anytime you look at my case, they budget the initial time. That doesn't mean that it couldn't go on longer.
And the first time I'm hearing that this specific dates are not adequate is April 30th in your filing. That's a fuck up. Sorry.
Remember, we all thought that the state's case was a day or two before all this because the trial length was still the same, and we're the state must not need 2 days to do their whole case. But she didn't even ask them, so no one knew.
Wait, can you just give a little bit of backstory to that? What do you mean? What happened?
I guess after they did the speedy demand and we got the new trial date and whatnot, and we're just kind of going off of the docket and what's being posted. But I guess I remember being on this channel and others where we were all kind of I guess the state's case is 3 days because it's a 2.5 week trial.
Oh,
and we
gotcha.
knew that the defense's case was going to be longer.
Okay.
And the fact that she didn't even ask the state how long their case was going to take, which is what comes up in this hearing.
Okay, that's true too. Yeah.
Where I guess it comes up in the email, I think, that Rosie published, where the state where she does the whole third party, you haven't proven it to me yet, and and doesn't ask the state like how long their case is going to take.
Okay, gotcha.
Right, and I mean that's where what it just keeps coming up as far as like, you know, it was previously mentioned that the defense was going to need a 2-week case. So like how, like I mean I don't.
She
I
just
mean, I
puts
think
things
there's
on the
some
docket.
indication. Some things are just. I mean, it's good to have the transcript because this was completely misconstrued in reporting by a lot of people, and it reads completely different than how it was presented. But there's some like very specific instances where you can kind of see like she knows that this is going to be an issue and she doesn't want to solve the issue. I mean, she's railroading it towards the situation where the prosecution is definitely going to milk the clock and cause a bad situation in a bookended trial. And you know, she's not going to do the hearings on the Franks because she's anticipating, even though we know that she isn't reading things as they come in, that she's going to deny those without a hearing. So you don't need it. I mean, there's a lot of premeditation on her behalf on this.
Yeah.
Like the details to like a news exclusive of like how long the trial was going to be and like what the jury questionnaires and like just like the information on jury selection. But then it just became apparent that like she didn't even tell like the defense or the state any of that. She just announced it on TV.
Yeah, but I mean, Travis is right, and you know, Travis, I would love to hear your opinion as a, you know, an attorney. Like, it does seem like the defense has to be 110% awesome all the time, and they can't make any mistakes because, like, it's just going to get called out on them, kind of thing. So, I mean, ultimately, how would you have approached this if you were in their same situation? You know, yeah.
Well, I mentioned it last time, the last read through, and even before on things with Teresa, that from the very get go, you know, I'm putting in the judge's ear, and so when the thing would have been, you know, when they got set for 3 weeks in January, when they were talking about it in the June hearing, I would have been saying, Judge, no, you know, no less than 2 weeks, no less than 2 weeks. Now on this deal, there was an order issued. Well, there was the thing to the media that she talked about. She granted a media interview, right, about that they were going to be sequestered and this and that. That was bizarre.
Oh, yeah. Okay.
But then they got an email, and he says, page 7, bottom, and those dates, and my interpretation of the email, and I don't know when the email is. I presume the email is that date that she's talking about. I sent out the notice on whatever that this trial was going to commence on May 13th here in Fort Wayne, and that this trial was going to end on May 31st in Carroll County. And those dates, in my interpretation of the email, I think you used the phrase "not more or less." They're not flexible dates. He should have had an email back that day.
Gotcha.
But I think he does. He does email her back, and that's when they end up with this hearing.
Okay.
So that's
what. That's right. They trade emails back, and she says, "Those are the dates. That's it." Right.
It redacted a lot of the first part of that email, which may have been some of his response.
But this is like on repeat of like the contempt / motion to dismiss hearing where the defense didn't even really know if it was happening that day. And then like they got like whatever time was left, like at the end, and Baldwin asked for 2 days and she's like, no, not more or less than 1 day. Like that's it. So
yeah, and then like having to, you know, the whole reason that I think they're getting more flustered too, and, you know, not being 110% awesome is because, like, you know, they're too afraid that Alan's going to die. So they're rushing to do the speedy trial before she kicks them off again. And, there's all this, there's like no time to think. It's a very much like we have to be perfect but constantly on our toes, and we can't make any mistakes. And I think that's exactly where she wants it. But I had a legal question about recusal.
Okay, well, hold on before you go there.
Okay.
I have a
Yeah.
question about this still. So
Okay.
my I don't understand how there's not something like he's saying where he practices law, where he makes a living, that there is no end dates. Like the
Right.
trial might be set because they have to have the courtroom,
Mhm.
but there's no end date. And she's like, well, like that's just not how we do it here. So for me, I feel like the defense didn't come forward and start saying, hey, we have a problem with this schedule until she sent that email saying with the bookends, like,
Oh.
it's no more, no less. So they didn't know that they had to go and approach her because they didn't know that she was going to make it so final that the
Yeah.
May 31st was going to be the end all be all. And so when they realized that, they were like, wait a minute, what? We can't. So there was no, like, she's like, I wish you would have come to me sooner. But it's like,
Yeah.
where they practice law, they don't have to come to the judge and say, hey, if the trial takes an extra 3 days, is that going to be an issue? So my
Right.
question is, in Indiana, is there anything in black and white in any of the Indiana codes of anything that states that
No, there's not.
so
Okay.
she did that on her own then. She's creating an end date because that's just
Okay.
her practice of what she does in her courtroom. But she doesn't make sure to make that clear up until the emails on April 29th or whatever day it was, right before this, request
Mhm.
comes in. So
Yeah.
wouldn't that
I think it's just a matter of practice with so with their docket system that's uniform throughout all of their felony courts. They when it gets set for trial, like y'all have mentioned, they have those whatever number of days the clerk initially puts in. I'm sure the judge tells them, set it for jury trial. In our system, it just says set for jury trial, but there's 20 cases set for jury trial. The normal jury dockets are for 1 week. And then when the bigger cases come in, and all of mine take more than a week, which is why you have to be extremely careful with this stuff. The judges don't set a firm end date, but they talk to, in a normal case, I'm talking to the DA, and we'll talk before the weeks leading up to the scheduling conference. We'll talk the morning of and meet before we go in. And we both typically realize it's a fight with the judge to get the total amount of time. And judge is trying to restrict the state, trying to restrict the defense. Anywho, so, we usually go in there combined and say it's going to take a total of 3 weeks. And so the judge won't set an end date, but everybody's informed. The juror commissioner, the juror office in Indiana, everybody's informed that it's going to take about 3 weeks, and they'll put a start, and they'll block out those entire weeks. And then if it goes over a day or two, so for example, let's say it does finish on time on the that Friday, the 31st or whatever it was, but the jury goes on and deliberates for another 3 weeks. Judge can't stop deliberations, can't say, wait a minute, I'm going to give you 8 hours tomorrow on Saturday to reach a decision, and otherwise I'm declaring a mistrial. I mean, she'd be lynched. And,
Mhm.
so, there isn't an end date. And so that email probably did catch her by surprise. And I bet, she just says stupid shit when she gets backed into a corner. Like, we've had an unexpected turn of events.
Mhm.
I can't believe you never told an end date. Now, if both attorneys get in there and say it's going to take 3 weeks, and then the second week of trial, they're like, well, Judge, it looks like it's going to be more like 6 weeks. You're both going to pay. State's going to pay. And then, a case that scheduled for a week, and if the judge thinks some of the cross-examination's been stupid, futile, and now there's only like a day for the defense to put on their case, they'll tell them, no, we're ending today. We'll go all the way to midnight if we have to, but we're going to get this trial done today. And it's defense. It's I'm not going to say anything, but they're going to figure it out. It's your fault. So do what you want to do. And
Well, then it seems like a matter of just not communicating well. Like
And
nobody.
clearly.
Yeah.
At a hearing, like she never schedules another hearing at a current hearing, so there's never like any checking
Gotcha.
in.
Yeah, that's true.
Hi, Bob.
What's up, T?
How's the grandbaby?
I'm waiting for her to get here. As soon as that doorbell rings,
Oh,
I'm out, bro. I'm out.
congratulations.
She had a hair.
We haven't laid hands on her. Our daughter-in-law would not allow anybody to the hospital, which I ain't sweating her on. I imagine giving birth is a pretty taxing thing, and I can imagine a parade of people coming through would be pretty boring. Getting pretty old pretty quick. So, and plus she was only in for 2 days, so we're excited. We're excited.
Mazel tov, Bob.
Thank you.
Congratulations.
Appreciate that. We're excited. So what are you guys doing? Talking shit? You in here talking shit?
We're in here talking shit now. We read through the hearing transcript from May 7th, the one that you were on vacay for.
Yeah.
It was super short and sweet, but we read through that, and now we're just talking about it and talking about whether how this actually should be working and what the dysfunction of their communication is and why nobody can seem to get on the same page.
Hey, Bob, in Chicago, over there in Chicago, on a lengthy trial, 3 weeks or longer, they don't give, y'all figure it out with the prosecutor. Y'all say, okay, how long your case?
Right.
Well, the way you cross-examine Travis, going to be double normal. So 2 weeks for my case,
right?
Week for my 3 weeks. Okay, so let's agree. We'll ask for 3.5 weeks. Wink, wink. Okay, yeah, that works. Okay, because you never know,
right?
And then, but there's no definite end date.
Never.
But they might put an end date, like in the jury questionnaire. Or the judge may say at the beginning, the attorneys have told me they estimate it's going to take 5 weeks to try this case. Does anyone have a problem with that? But other than that, I mean, does it work different in your neck of the woods?
No, I've never had a situation, number one, where a judge has not advised potential jurors. It's basically one of the first things they say, that we're estimating this trial could last X amount of weeks. We've never had a judge put an end date. I mean, they can give it like an estimate, but we've never had this was unequivocal from her. Her whole, this isn't a more or less thing. This is the day it ends. It is absurd. In my position is clear. I've stated it without any kind of hesitation. She knew that they were going to have to ask for a continuance when she set that date. She knew it. There's no way that she really thought, I don't care how many cases she's tried where, where there's been multiple homicides and they've gotten it done in 2 weeks. She knew that there was no way that this case is getting tried in 2.5 weeks, because you have to count the 3 days for jury selection. So we're talking about really 13 days of court. And there's no way possible. Just looking at the jury, the witness lists, you can tell, even if you have the most time conscious attorneys on the planet trying to get through all those witnesses, all the witnesses you need for getting evidence and, laying the foundation, authenticating shit. And on top of that, all your fact witnesses, it's like, there's no way possible. And she knows exactly what they're coming at the jury with respect to a defense, whether or not she's going to allow it. She's going to have to allow some form of it, whether it's like what Judge Cannoni is doing in Reed, where she's forcing the defense to develop their defense through cross-examination or what have you, and then determining whether or not they've, shown enough for it to continue into their case in chief is one thing. But, for her to say, I'm inclined to deny it, knowing what's out there, to me, the fact that 3 cops worked on an investigation for 2+ years is enough to know that a jury should hear it,
Right.
That's just my opinion on it. Whether or not it turns out to be bullshit, I have no idea. But it's certainly 3 cops who were all, as far as I can tell, legitimate cops, thought very differently, So in my world, that warrants a listen. And
Could I ask the legal minds a question real quick, and I'll take my answer off air. But I was just wondering, how would a recusal work if, there's a miracle and she does recuse, and then what will happen to all those motions? Will they have to be refiled and asked for again?
No, they won't.
No.
So chief judge would appoint a new judge, or the Supreme Court would put a new special judge in there.
Okay, and then that judge would have to hear all the stuff that she didn't go over?
Yeah, correct.
Oh, man.
So anything that's still pending, which is voluminous at this point,
Right.
The new judge would have to hear. Like,
That
I
new
agree with
judge
Travis.
should
I don't
go.
think there's any chance that she's recusing herself.
Yeah.
So the
Dang.
question is then going to become, what do they do? Do they file the interlocutory appeal? And that it is, if they do that, this next trial date is getting kicked, because there's no way nothing can be litigated while the appeal is pending. And it's not going to be like the Supreme Court was, where they fast tracked it. It's going to take as much time as it's going to take the appellate court to get to it. I'm sure that they'll bump it up the list, but in terms of when we're going to get an opinion back on it is impossible to know. But what I can tell you is that there's no way, with everything that still has to be litigated that's currently filed and everything that's going to be filed, there's no way that October date's going, because again, like this, whatever it is, 4 or 5 months is going to go in the blink of an eye. And it's just how it works with trials. So,
Well,
they're going to have to make that decision whether or not they think that Rick Allen's going to survive.
Will Mr. Osbrook be able to look at that?
I'm sure Michael will definitely be taking a peek at it.
Okay, so I have a question. So she, in the email that Rosie does put in that filing, she's essentially saying, like, I know third-party defense, and you essentially don't have that yet. Like,
right. Exactly.
I don't know what you think you need all these days for. But in this hearing, when we read through the transcript, she's like, if you had just come to me sooner, I would have given you all the days that you needed. And I'm like, no, you literally told them you don't even know what the hell they're talking about. And now you're like, oh, if you just said something before April 30th, it's like, no matter what, whether they say something or they don't say something, she doesn't care. She just uses it to maneuver how she wants this to go. And she now has the trial exactly where it was when Librato and Scremin were on.
But she knows she had to do offers to prove throughout the trial, right? Like if she denies a third party, she would know that that would have to take place.
Well, you would hope not. You're trying not to torture a jury here, and like sitting there doing offers, offers of proof, really takes a long time, because essentially you're having the jury leave the room, and it's a mini trial within a trial, where you've seen it and read a couple of times where they've done it. They clear the jury out. They allow the questioning to take place. The judge decides then whether or not there's enough there to allow for that line of questioning. And it's very time consuming. It takes, it eats up valuable time, because you see how in a trial, how it goes. You get, if you're lucky, the jury's in the box by 9:15, 9:20. You put on your first witness, depending on what type of witness it is. And, you're taking your first morning break by 11 o'clock. You're going till, and that's 10 to 15 minutes. You're coming back. You only have another 45 minutes. It's like, we're not talking about 8-hour days here. And, even in her world where she was going Monday through Saturday, trying to get 8 hours. And the reality is with lunch breaks and all the other shit that comes about, like sidebars, offers of proof, all those things are going to happen. The time just flies by, and it's just not pragmatic of her. That's why I'm saying, I like when she set those dates, she knew that this was the one way she could force, since her first attempt at getting the trial kicked from January worked, and that was by removing the attorneys. That forced the trial date to get kicked. And then when they got back on, they then filed the 70 days. So she had her hands tied. She had no choice, but that wasn't her deciding to do it. She had no choice but to set that date within the 70 days. And then she goes ahead and sets a super short date without consulting anybody, knowing that they were ultimately going to have to come. Like, she was just waiting. She's like, I don't know how long these guys are going to wait to ask for this continuance, but I know it's coming. Because no lawyers think that case is getting tried in 2.5 weeks. It's just impossible. So, like, to me, it was premeditated on her part. It was just like she knew it was going to get kicked. Conveniently, it was same damn date, like Travis said, that Libredo and Scremmens got. And interestingly, to your point, Teresa, she acknowledged that Scremmen and Libredo were going to be using that third party defense, and was talking about giving them a Franks hearing as well. So,
Right.
So you can see this different treatment from her handpicked lawyers to the other ones that were not handpicked. I mean, I think she selected them, but I don't think they were handpicked like she handpicked these two, especially Libredo. Libredo was her boy, like, dude's in front of her all the time, works in that courthouse every day. He's a PD. It's probably his room, her courtroom. So,
right. He's like, I know that she would not allow this trial to go any further.
Right. I mean, and he does. I talked to people that worked with Libredo for years, and they told me things. So
at least the different treatment put her bias on the record.
Yeah, well, whether or not, see, the interesting thing, and when I had Michael on last time, I asked him, is there any kind of rule in Indiana? Because here in Illinois, if we're seeking to move a judge for cause, it then gets kicked up to the chief judge of the criminal division, and it goes in front of them, and they assign, if it's for cause, they assign it to another judge, because the concept of a for cause hearing being heard by the person that you're saying needs to be booted is absurd. There's zero chance that she's booting herself off the case. As a matter of fact, she'll come back with the same response. The Supreme Court's already heard this. I realize you threw a few more things in there, but it's essentially the same shit. And I'm not biased. I don't care what you say. Where you read these words, and if I said those words about anybody, if I said those things about Travis would certainly think that I was biased against him. And everybody that was out there would think that I had a bias against Travis, because I'm saying, oh, he's sloppy, he's incompetent. He's, grossly negligent. like that is bias. That like she's let her private thoughts slip out of her mouth for the whole public to hear. And I just don't see how an appellate court would say, you laid it out there. Like you can't unring that bell. Like if you would have kept that to yourself, like in and of itself, looking at the record, it's probably not enough to get you booted. But when you lay it out there that that's how you feel about these attorneys, and then you compound it by in the very order that you're writing, wherein you're stating that McClellan did not have enough evidence in his motion in terms of that hearing, but you still decide to put those words in there, it's going to have an effect on the jury pool. It just is. Everybody, like people, we're supposed to trust judges. Those robes, they wear those robes for a reason. They wear them because it gives them an air of authority, and it works. People have respect when they walk into a courtroom and they see that high bench with that judge perched up there in that black robe.
Mm-hmm. And that's scary as a juror because or as a person on the outside, knowing that the jury is going to look at her as the end all be all to everything.
Exactly. That's the whole point, is that when she's sitting there shitting on this guy's lawyers, and inevitably, especially because it's in her county where she's a sitting judge, they're reporting on it more than they would be if they had picked a judge from another county that didn't have any kind of real media coverage. But Fort Wayne's a big town in Indiana. They have their own papers. They got their own shit. It's not like the Carroll County Comet. They have multiple news agencies, a full-blown newspaper. This isn't like the Orange Gazette that you pick up walking out of the Aldi. It's like a real newspaper. And they're reporting that these lawyers, that this is what this judge's opinion is of these attorneys. How can you expect any prospective juror that's heard about how she feels about these lawyers to not go in with some kind of preconceived notion that they're shitbag attorneys?
And they're not supposed to have
you can set the
whole point.
Yeah, you can set the whole whether she's biased or not completely aside. The appearance of bias is, it's got to be at 100%. There's no way that
100%.
there isn't the appearance of bias.
Absolutely. There's, appearances are everything. You know what I'm saying?
What's that? Do you have something to say? I didn't mean to interrupt.
Who? Me? I was done. I said my piece. You guys know I'll talk all the whole fucking time, man.
You actually did really well on your live today.
I know. I kept quiet.
I was like sitting there going like, Bob is probably the quietest I've ever heard him.
Well, that was the guy who actually wanted to hear what he had to say.
You saying you don't want to hear what we have to say, Bob?
Yeah, no, I do. But like that guy really, like I was truly anxiously waiting to hear his kind of evaluation of that, because I think what he does is really interesting. It's really thought provoking in terms.
It was a good live.
Yeah. Anybody can see that. That was great today.
Yeah, he's a really, really bright guy, and I really do want him to do the 4 Avery interviews, like parsing it like that, because it's so enlightening, because he looks at it in a different way, and it's really, he is kind of like the lie to me guy, Tim Roth on that show.
Yeah,
somebody had posted it in the comments. I'm like, yeah, that's spot on. And I enjoy what he does. I think it's a very useful tool.
Is this a case where they're going to have jury consultants?
I don't think they can afford them.
Yeah, I don't think
that's what I was wondering.
Do you think that Gull standing behind her the Supreme Court voted that I'm not biased, so I can stay on, is pretty much like obliterated because there was no record before, even though the argument was that they wanted the special judge removed based on the fact that she removed them without having any evidence, and that was basically the bias, where now there's a bunch of things actually on the record that she said and done that will move the needle in the other direction?
I think it's going to be a totality of the circumstances. I think it's going to be a record that's replete with giant gaping holes, a record that filled with motions that went ruled on without hearings and without any kind of basis in fact and conclusions of law. She just didn't give any opinions on why she's denying things. I think that they're going to look at the language, that she has consistently been speaking about defense counsel. And to me, if they're on the up and up at the appellate level in Indiana, I don't see how they're keeping her on. But what do I know? It's like I've been practicing law long enough to know that, to expect the unexpected because nothing's predictable.
Hennessy said it. The one time she didn't say denied without hearing, she shot herself in the foot.
Right.
Like, why did she do that?
Who knows? I don't know. It's like, I know that like Sleuthy's dug into her record some, and I have not decided to dig into what she's done. I mean, Travis has sent me some stuff about her as well, and she's been on the bench a long time. Like she's not
27 years.
Yeah, I mean, she's just.
I don't know if
think
she's talking about all of her
hundreds
cases for
of
27 years. she's been
trials.
doing it.
Like I've been in front of judges that are long in the tooth on the bench, and you could tell they're done. It's one thing to not, that they're no longer going to suffer fools up there, but it's another thing to just flame throw the system in terms of the size and magnitude of this case in that state. I mean, she's got no regard for anything, it seems like to me, with respect to how this thing is being done. And more importantly, she doesn't seem to acknowledge the fact that what she's doing very much, I believe, will result in this thing getting kicked back on appeal, even where it stands now, because it's been so disjointed. Like if I'm the appellate lawyer, I'm absolutely making the argument, if he's convicted, that his Sixth Amendment right to a speedy trial was just destroyed when she removed those lawyers. Like there's no, you can't make that up. There's no making that time up. It's like saying, okay, well, they filed the 70-day. Well, they had to, but they had a trial date of January 8th, which she saw fit to make sure that that wasn't going to happen. And she did that by removing the lawyers and knowing that new counsel would need time to prepare. I mean, that would, like, you don't have to be a lawyer to figure that one out. I mean, that was clearly the move for her. So, I think when an appellate court starts looking at it and, these guys get back on the case, it takes them another month to get acclimated and for McClelland to get them the records back. And like, they're going through the process of, and Travis can attest, when you get discovery of that magnitude and you've got to relook through everything, because however you had it set up initially is useless in terms of your base stamping, in terms of like whatever kind of, kind of cheat sheets and, indexes you may have made for your purposes. It's all changed because they've shuffled everything around. And you have to make sure that everything that you had is still there and that they haven't stuck shit in that you didn't see the first time, hoping that you won't see it the second time because you don't have time to go through it all because you've got a trial date looming, and like McClelland's very quick to use that against them. Oh, it was in there. You're just not looking well. And, like he pulls that shit all the time with these guys. So
that's because discovery is a disaster, apparently, but he thinks it's okay because he has it the same way. And then when asked, it was just the most ironic thing, because then when he's asked about an email to Hennessy, he can't figure out whether he sent it or he didn't send it because everything he has is a fucking mess.
Yeah.
And he never had to prove it. He just said it in the hearing, right? And just went
I think they ended up dropped that part because he couldn't find the email. Mandy wants to know, Bob, if you will have Jack do some Delphi people.
Like who?
Any of the interview footage from like families, the sheriff, the probably like a lot of like the down the hill stuff. I don't know. That's kind of what I'm thinking, like that documentary, because that's probably other than that, there's just a shit ton of clips.
Yeah.
They have had some interviews on other channels but there's not a huge thing really look into, especially when it comes to
Yeah, that's what I'm saying. Like
This is where
now.
we have a bunch of clips and like very limited statements, like on a couple of talk shows. You know,
Right.
Yeah, I mean, like I'm sure Jack would look at anything that I gave him to look at. You know, if I beg him, like, here, man, could you please look at this? Just let us know if they're lying. You know, it's like, yeah. I mean, I wish.
How about the Patrick Westfall interview?
Yeah,
that would
That's something we got on tape.
on sleuth intuitions thing.
Yeah.
That would
Or
be
how about Judge Golf coming out and just saying, there's been an unexpected turn of events. There absolutely has been.
yeah, there has. Yeah.
So I have a question about this. So the motion to dismiss. Am I under the correct impression that they filed it, I believe, the 20th? Am I right in the fact that Nick has 10 days to respond to this, and then she has to respond within 30 days of when he replies? Or
No,
is that
it's
not
all stayed? It's until there's a ruling on this motion to DQ. Nothing
right?
happens.
That one. I've
Yeah.
dismissed. I'm sorry, I said the wroong thing. On the motion to DQ, I apologize. I said the wrong thing.
Yeah. I mean, there's going to have to be a time frame.
Does he have to respond, or did he just not respond? Does he have to have a response to that?
No, I mean, he doesn't have to. I mean, he's
So then how long does she have to reply to make an order?
I think
I don't
30
know. Yeah,
Just
30 days.
30 days from final submission. So he has 10 days to respond. If he doesn't respond, McClellan has 10 days. If he doesn't respond, it's finally submitted, and she has 30 days from that date. If he responds, they can reply. They file a reply. It's 30 days from the date of the reply.
And she has 30 days to certify if they wanted to do an interlocutory appeal.
I mean, I thought it was weird that Nick McClellan brought up that he would want to respond to the motion to disqualify. Like, why does the prosecution care?
Because he kisses her butt.
Well, I mean, then that's kind of like, that proves the point that there's some bias there. I mean, I don't get why one side, like, the prosecution shouldn't care who the judge is, right? They should be interchangeable.
Yeah, most of the time they don't respond, but every once in a while they will.
Hey, AJ, I think I can hear you.
Yes.
This time.
Oh my
Finally.
goodness.
Yes.
Thank goodness. Finally.
So AJ was at this hearing on May 7th, the transcript that we read through. So I know that she had some thoughts on actually seeing it being read or hearing it being read versus actually seeing it in person.
Yes. And forgive me because I've been trying to get on. I haven't heard what you guys have said for the last 35 minutes. So if I bring up anything that's already been talked about, I apologize. But the first thing I wanted to mention was hearing it back. I wish you guys could maybe see the eye rolls and the heavy sighs. And I mean, there were a few times that Rozzy even like paused and didn't even say something because he was so exasperated by her. Those are things that you can't get from a reading, that it was just like, oh, it was just unbelievable.
And what was the feeling in the courtroom when he was telling her, you don't know anything about this case, with all due respect, what was that feeling about?
Yeah, he definitely was very passionate. I wouldn't say he was yelling, but I would definitely say he was very passionate about it. He just, to me, it felt like he was trying every which way to keep the trial going, and she wouldn't answer. Us sitting in the stands were saying, why doesn't he ask her if her setting an end date has not worked before? Has she ever been in a situation where that didn't work?
I think that we could probably look at some of her previous trials and clearly see, what they were initially scheduled for and what they ended up being. And I mean, it can't be normal that you set a trial for 5 days every single time and they're always exactly 5 days. Like, that's not reality.
Rosie
I don't know why
a really long trial in his motion to have a pretrial hearing. I think he found a trial of hers that went like at least a month.
Oh, he did, but then she
I
makes
would-
sure to rattle off her entire resume of I had this trial that was scheduled for this amount of time with this much evidence and these many witnesses, and it only lasted this amount of time. So, like, don't tell me I don't know what I'm talking about. Essentially, like I know how to schedule this stuff.
None
Let's
of
talk
those
about
trials-
that for a minute. So, and get Bob's impression on this. So, bottom of page 20, she reads off a resume. Bob Leonard, scheduled for 34 days, nearly 140 witnesses. What you didn't include, Mr. Rosie, is I got that case tried in 20 days with 161 witnesses, 2,000 items of evidence. Cohen Barron, life without parole, murdered his girlfriend and 3 children. We tried that in 7 days, 36 witnesses, over 200 items of evidence. Pope, life without parole, tried in 4 days, 2 victims. Dustin Neals, 2017 murder, tried in 2023. I tried that in 4 days. Tried a death penalty case early in my career in 2.5 weeks with 4 victims. And I'll turn this over to Bob, but you know, that's scary in one sense.
Yeah.
Bragging about how quick she can
Make the wheels of
somebody
justice
sentenced to
turn.
death. The other
Yeah.
scary thing is, you know, it's like sports. So, you know, it's like the Bears.
Easy
So,
here. Tread carefully.
You know, it's like, you know, Green Bay, the quarterback says, yeah, you know, I'm won my last 3 games. My last game, I had 400 yards passing, and it was against the Bears. Who cares? I mean, so the analogy here is, in any of those cases, was there a full-blown legal confession? Most death penalty cases aren't about guilt and innocence. They're about life or death mitigation. Who were the defense attorneys on these cases? Those handpicked ones that she has, or, you know,
or are they public defenders, or are they private counsel? I mean, there's a
There
big
is
difference.
one case she removed the lawyers.
Yeah, and it went up on interlocutory appeal.
And then the defendant was like, I don't want to wait that long, so they pled.
He pled the life because
It
it
just
was a
went
death
away.
case. Yeah.
Well, and that's another thing too, is when she made the comment that she's only there to call balls and strikes. And, you know, there were a few are like, well, then why is she also calling people sloppy and negligent and grossly negligent and all that? You know, if that's all she's there to do. I just wish he would have brought that up, that she's definitely doing more than that. Especially bragging about the cases that she's already run. But
I mean, they did in their motion to DQ, you know, Baldwin went above and beyond. I think I think Baldwin drafted that. It might have been Rosie. I don't know. It's like, you know, the ironic thing is it's like when you look at who's writing what motions, it's interesting. And like Andrew Baldwin has a much more prose style of writing in terms of legal documents. I'd say that Brad's more traditional, and in terms of his legal writing, and you can always tell, like I can always tell, like I could definitely tell that Auger had written that memo of law attached. That's just, you know, like that's somebody who writes. That's like Allison's writing. Allison's like case heavy, you know, cites a ton of cases.
She's that way on the channel too.
Yeah, exactly. I mean, that's her thing,
Love it.
you know, and it's a credit. That's what you want for attorneys. That's what the entire basis of the law is precedent.
Baldwin is repetitive. Baldwin, and if I know it's Baldwin's, as soon as they start repeating the same exact phrase over and over and over again.
Like, I had an explanation for it, you know, but and I think that it's true. I think that he has a tendency to kind of beat her over the head with certain things. because I really think that he doesn't believe that she's read anything. And I don't think that he's crazy in thinking that.
Well, no, because don't you think that she would make a comment about how repetitive he is?
Yeah. Like, you say the same things over and over. There's no way I could forget it, Mr. Baldwin. I mean, he sets himself up for snide comments, and she never makes them. How could I not know what you're talking about, Mr. Baldwin? You repeat them on repeat over and over, like a loop, and like she never says that kind of stuff. And obviously she had kind of shown her hand early on when she said, I haven't even made my way through the memo. And that's like 4 months after it was filed, and I definitely haven't looked at the exhibits, which obviously are critical in understanding the memo from their perspective. That's where all the receipts are. If you're not going to look at the receipts, then it's just a bunch of words. And she hadn't even gotten through the words. So
and then she did it in a weekend.
Right. Like magic. Boop. There you go. Denied without hearing.
Bob, can I ask you a question?
Sure.
On May 7th, it was a 2-part hearing. And the other part was to hear the motion in limine about the third party being allowed, correct?
That's what it was planned for. Like, I was
Why
tortured.
did they not do that first? Because if the third party wasn't allowed, he wouldn't need those 15 days. Like, why was that never figured out?
They circumvented it by filing the motion to DQ. That DQ puts a brick on it, stops everything. She can't make any.
Okay.
Once that's filed, she can't rule on any substantive motions at all.
But they had that. The question for me though is they hadn't put that in yet. He doesn't even mention it until the end of the hour hearing, but she hadn't seen it yet. Why didn't they do something? We talked about this earlier too. Why didn't she utilize this day of court that she already had set aside to hear things that could have been heard that day?
Amount of time. Yeah.
To me, it would have been a semantical argument that she refused to accept service of it on the bench. And obviously they were not in Carroll County, so they couldn't file it with the clerk. Why they didn't file it electronically, I don't know. But I think that her thought process was, well, she knew it was coming. I mean, she knew unequivocally it was coming. They probably sent her a courtesy copy that morning via email.
The courts were all closed that day.
What day? The 7th?
Election day, the day of the hearing.
Well, her email wasn't
out of there
closed.
And make the McDonald's breakfast hours.
Yeah, I mean,
Dean, what did
they had already filed the motion to continue. They said that they weren't ready. She had granted it in part. She had granted their continuances to, I think she had granted the continuances to the third party culprit and McClelland's motion for admissibility or inadmissibility, right? Or is that the same thing? That's how it came about. His motion is motion to eliminate for inadmissibility of third party culprits, which she then morphed into them proving up their defense. And I forget what the other one was, but she had continued 2 of them. And at that point, she's like, screw it. I'm not doing anything. Screw you guys. I'm going home. Like Cartman style.
Fiend, you were there as well at the hearing, correct?
No, not this one.
Oh,
not this one. Yeah.
Oh,
I was like, wait a minute. You better not have been. I would have asked you already.
I wish you guys could have seen it when Baldwin, raised his papers up in the air to ask the judge if she wanted a copy, and faced it towards McClelland as well. But it was like a peacock. It was just like it was funny to see. Oh.
Well, they ended up adding like 6 pages to it anyway. So.
Well, more than that, because it was 24 initially, and then it ended up being 42. And I know you can see it because I was just reading the transcript, but I was also holding up papers, waving them around.
And one thing that wasn't on the transcript is that McClelland, when he brought up the what was it? The thing that he brought up about the things that he wanted seen. I can't think of the words I want to use.
Motion limine?
No, the suppression. He said when he said it was very damning. He used those words very damning, but mumbled it, and that was definitely not in there.
Is that what DB's asking about right now?
AJ, there's a bit of rumor that Rosie called Judge very. Did you hear? I did not hear that. No, I didn't hear those words. But I did hear when he was just bringing up those papers, he talked about, I mean, you guys read it, and I don't know what the exact words were, but when he put the paper down on his desk, he said, very damning. So,
Wait,
that's what Nick said?
There's no chance that Rosie called her a name on the record.
Yeah,
I wasn't there, but I would bet a large sum of money that he didn't call her a foul word. I mean, they're on thin ice with her as it is. They're not going to, you know, and I mean, at this point, Brad's sick of her shit. You know, I mean, he's like the time for reconciling is long gone, like any chance of that happening. So, I mean, I think in the eyes of the defense attorneys, it's scorched earth. You know, like they just don't care. They don't practice in that county. I mean, not regularly. I know Baldwin has some cases up there, but for the most part, you know, that's not their county. They're you know, it's so you have more leeway in terms of your approach in a case where you're not in front of one of your normal judges. Like it's Allison and I do the same thing. I mean, when we're in front of our judges that we're in front of all the time, you know, we want to maintain a decent relationship with them because we don't want their dislike for us to you know, get put upon our clients, you know, in different cases. So I don't know.
It's interesting that she said that the thing that Nick said wasn't in the transcript, because I know for the last hearings, some of the stuff was changed in the transcripts.
Like which part? Do you remember?
Yeah, with the last ones, a lot of it has to do with backdating Holman as lieutenant, even though he wasn't promoted publicly until after those hearings, but they backdated it and put in both of the transcripts, not even just like in the, you know, in the title, like saying who's speaking, but also in everybody else's like statements about Holman. Like they changed sergeant to lieutenant, which is kind of crazy.
But
they also put
sergeant.
they also said
yeah, they were calling him sergeant, and they changed all of them.
They also said Skip called him Fig Newton, which is hilarious, but certainly not what he said.
I love Fig Newtons. I don't. No one's going to sit here and blaspheme Fig Newtons. I'm going to tell you that right now. They're delicious.
I haven't had a Fig Newton. I couldn't even tell you how many years.
They are super underrated. I'll just tell you that.
Oh right yeah, it's the other thing was that I thought was hysterical is that McClellan doesn't know Mullen's name. He calls him Mr. Mullen, Mr. Mullins, Detective Mullen. Like he doesn't know Mullen's name.
I mean,
well, that part they probably should have fixed in the transcript just to spare Steve's feelings.
Names are hard.
There
Names
since
are
what,
hard.
2020?
Who this knows? Who this knows? Fig Newtons are delicious. Yeah.
Isn't it just Mullen? I think it's just there's no S on it. I think
There
it's
is,
just a
but
Mullen.
he goes back and forth the whole transcript.
Steve Mullins. What makes more sense? I think Steve Mullen makes more sense. Right?
I think it's Mullen. I don't think there's any
like Sleepy said.
It is. It's Mullen.
Yeah, that makes more sense. No S. Huda says no S. Sleuthy says it's literally his investigator. Nick's a loser.
But Lynn said the search warrant was valid. The search itself was reasonable and legal under Indiana law and Fourth Amendment case law. No Franks changed that.
Hey, Lynn, can I get a case citation there? Thank you. I'll be waiting.
Allie'd be like, let me just find that for you real quick. I've got it right here, Bob. Just give me a minute.
Yeah. Lynn's not a fan of the defense team at all. She thinks they're the problem. It's cute. It's adorable. It's a
I
cute
think
look.
that she really more thinks that the Odin stuff is the problem, and
I
that's
think
kind
she
of
thinks everything that has to do with the defense is the problem. Their theory, the lawyers themselves. I mean, Lynn's been hanging around for a minute. I respect her. I mean, she's absolutely entitled to her opinion. Who am I to judge? You know, I don't know.
She sits on the fence on Karen Reed. You know that, right?
What? No way.
Yeah, she sure does.
No way. Is that true, Lynn? Are you on the fence on Karen Reed?
I'm surprised by that.
Lynn's my favorite.
I like Lynn. She keeps me on my toes.
I do too. I would never not want Lynn in my chats. She keeps people honest, you know, and she's unwavering. She's unwavering.
Right.
You know, I respect that.
Unindicted said he's allergic to figs.
That's sad, man. Like this new thing that's been around for about the last 10 years is that fig spread. You know, like when you make it like a real hoity-toity charcuterie plate and you've got like all the nice cheeses.
Do you do that, Bob?
God, yeah. I've got class, T.
Oh, I cut up some cheese and put some crackers on a paper plate, and I'm like, there you go.
Yeah, I mean, the reality is I can't eat cheese because I can't digest it, and it tortures everyone around me. So I rarely make charcuterie plates, but I'll eat some meats. I like some sausage. Sausage is good.
So Susan said, I don't think that I don't think Bob would have probably paid her any mind. So yesterday I was doing my Karen Reed recap.
Mm-hmm.
This lady comes in, and I was talking about the kids testifying, and she comes in and she's feistier than shit. And I got pretty pissed and ended up telling her off while I was live. And Susan won't stop giving me crap about it.
I mean, Susan will bust some balls. Like Susan,
yeah, she does.
I love Susan. She's good people's. Susan is definitely family. I love that case. It's been a joy to watch it. And it's like I keep telling people, and I was telling people like coming into it, I'm like, we have two cases that are very unusual in it, and it's like both the two most toxic true crime communities are revolving around these two cases. And it's because the defense put their theory out there in both those cases. It just doesn't happen where they put their entire theory, and it's not only a theory, but they're actively pointing their fingers at somebody else. You know, that's what makes it different. So you get people on both sides that say, hey man, yeah, this defense theory, it's got some legs, you know, and then they're all in on it. And then you've got the people that are all in on the state's theory. And then you've got these two warring factions, and you've got all the reasonable people sitting right there in the middle, taking all the shrapnel. And that's me. That's Teresa. We just take the shrapnel. And it's like, you know, like I say it on repeat. I'm like, people keep saying I'm this or I'm that. And like, I don't know how many times I have to say, I haven't decided jack shit because Reed is still in the middle of trial and Delphi, Rick Allen's case is nowhere near going to trial. Like I don't know what the evidence is. You know, it's like whatever.
But people are like, okay, so if you sit on the fence, then what about Koberger? And I'm like, nah, I think he did it. And people don't. People don't get that one.
Yeah, I'm the exact same though. You know, but like,
I mean, I kind of had to check myself on that because I assumed I was right there with you, but now I'm like kind of.
I know now they're like
I'm trying to second guess myself a little bit just because.
Yeah, they're sucking us in with the whole.
Completely fair to just like be 100% convinced on something.
Well, plus they're filing, you know, some of their motion, you know, that Ann Taylor's filing have some merit. What?
Genetic
there's some weird. There's also some. I mean, DB says check it out. Yeah, there's some weird stuff with the Koberger stuff.
There is.
Right.
There is.
This is my whole thought process on all three cases, legitimately. Like, if you can have a defendant who's guilty or innocent, and it doesn't necessarily equal that, like, or the law enforcement or the prosecutor or Commonwealth in Karen Reed's case are fucking things up, doesn't automatically equal innocent or guilty. Like, I can think both. I can think that there's a chance Richard Allen is the right guy and still not like Gull and think that law enforcement screwed everything up. And that's kind of where I'm at with Koberger. I still think they have the right guy. It doesn't mean that I think that they did everything right. So it's like those two don't always like equal out for me. And I think that's where people kind of get confused, because like with Delphi, I am more quote unquote pro defense, but that's only in filings. Like that's only with what's happening in the courtroom right now.
Right.
In any
Versus
cases
whether I
where-
think he's guilty or not.
Any cases where Ellie is being, pointed at for doing a shitty job, it's like if the case goes guilty, like it just, blows over and nothing changes. So it does. It almost
I
seems
think
like no
it's
matter
also
how
the-
crappy Ellie is, it's like
Right.
it doesn't affect change after the trial.
I mean, that you're nailing it there, because my standard was Delphi, and looking at Idaho, I was like, well, that looks great, but like that doesn't mean that it's all completely good. Like there's still room for there to be a lot of error there.
Right.
My standard was just very, very low.
Yeah, look, man, there is no such thing as a perfect investigation. Like you're never going to find one. They're all going to have warts because it's human beings conducting them. So, but there's different levels of shittiness. There's acceptable levels of shittiness, and then there's unacceptable. And it's like I don't know enough about the Koberger investigation to call it shitty quite yet. I know that there's been some filings. I think that they're still attacking the probable cause. Like that's still alive and well up there in Idaho. That I think that she's got some valid points. Like if you can't really put him there via his phone, and we can't really say definitively that's his car, and you certainly can't see him in it, and you're left with their probable cause is essentially a sheath that has his DNA, but you can't get to that DNA yet because you have to look at the IgG that they went through in order to get the probable cause to make the arrest. You know what I'm saying? It's like you have to go all the way back in that case. And I think she's got, and judge, the judge out there, like no one's going to be saying he's biased for the state. Like he is very much not biased towards the state out there. I've been seeing things about him being biased towards the defense, which is unusual. All right, I got to bounce. It's almost baby time. The baby's on the way.
You got to go do the baby stuff.
I got to go hug my grandchild for the first time.
Okay.
All right, you guys. Love you.
All right, post pictures.
Bob.
All right, see you.
Darn, I had one more thing for him.
That's okay.
Well,
we can always do the
ask
text.
Well,
it.
let me.
We'll just make it up.
So we can ask Travis this part. As far as the recusal goes, after leaving that trial or whatever, I'm probably the only person out there that believes that she's going to recuse herself. But the only reason why is something that Ali had mentioned, and that was before it's always been the defense, saying that she has bias. But with the Richard Allen letter, there's now the presumption of bias. And can you talk to the difference between presumption versus, proving bias?
Well, I thought their statute said, one, like Bob mentioned, they don't have for cause. So the judge who you are accusing to be biased determines whether they're biased or not. And it's whether they have to determine whether it's actual bias. And then I thought their statute said, or the reasonable appearance of bias. And so
I just feel like she's going to feel Richard's letters more compelling.
and
That he feels.
tell me what that letter is.
Wasn't there a backup to the ones that the defense asked for, where it came from Richard?
The affidavit from Richard Allen?
Yeah.
To the motion to disqualify. I think
that's mandatory.
It's part of the requirements, but I agree with you, AG. Like I'm not sold that she won't disqualify herself or recuse in lieu of disqualifying herself. But I guess we'll see. But I'm not as convinced as a lot of people are that she just absolutely won't do it just based on her personality. Like I'm not convinced that she's 100% biased. I think that she's like probably just this is the way she is as a judge, and I think it's gonna be hard for her to overlook the reality that there's an appearance of bias, and I don't know what you do in that case except to get the hell out of there.
The contempt that they felt for each other in that court was palpable. It was just so thick in the air, and I just can't. I mean, like with them discussing that the communication is nil, I just don't see how they can go any further with her. I just don't know how that can be, how it will work.
Yeah, the tension and the Michael Osbrook said that, they need to get, if there is going to be an appeal, either direct action, which he thought that there was a path forward for a direct action related to bias, or an interlocutory appeal on bias, which she has to approve. And I don't think if she denies the motion, she would even grant the interlocutory appeal. But to answer your question, it's always easier to prove the appearance of bias than actual bias, because actual bias goes to what is inside somebody's head, other than legal bias, which is, within a certain degree, a consanguinity, which, is basically can't sit on a case of a relative. Consanguinity is in-laws, and can't sit on a case with a in-law if it's too close. So, that's actual legal bias. Or if you own stock in a corporation and that case is a criminal defendant, things of that nature. But the appearance of bias, you're going to have a written record of. And so it is easier to show and prove that. But again, you're back to square one when the person, when you don't have an outside person making the determination, hey, from the outside, this looks like you're biased, when it's the person who is determining whether they are biased or not, or whether it would look to a reasonable person on the outside whether they're biased or not. I mean, just think about how silly that is. There's so much unconscious bias. I mean, it's ridiculous.
Travis, now that she's literally putting her feelings into her court orders that have nothing to do with the legality of why she's choosing to
she's
rule
not
the way
gonna,
she
she's not going to think that's an appearance of bias. She's just going to think, hey, I'm a fact finder. That's what judges do. And
there's no jurisdiction for her to hear the contempt hearing.
I think we missed the question. Say it again.
Oh, I was just saying she had no jurisdiction to even hear the contempt hearing. So whether or not she even put that stuff on the record, like, she went above and beyond even having that hearing to begin with. And it would have been great if she would have found them in contempt, because then Osbrook had the play to go.
That's a defense argument. The Supreme Court, unfortunately, in that order, granting the OA in part and denying it in part, gave McClellan the green light to pursue contempt. I mean, that second part of the opinion was just horrific. And, we're not going to disqualify her. And, the remedies are contempt and or sanctions. And next thing you know, there's a motion. I think they're going to be hard pressed, as great as the filings were. I think they had really good arguments that stuff didn't need to be decided going into that trial. Could have waited until after. And then ultimately, she's A-okay, because she didn't find any contempt. So there's nothing to appeal. But it's
Does she have a certain amount of days to answer?
we went over that. There's 30 days to decide it after it's finally submitted. Finally submitted is defined as the date that the state has to file an opposition. If they don't file an opposition, it'll be 30 days from the date it was due, which they have 10 days after it was filed.
Oh, shoot, I was looking at that. When was it filed, did I say?
And then whenever she denies it, they can file to have her certify it to go for an interlocutory, and then she has another 30 days just to even grant or deny that.
Okay.
Right, which she'll deny, and that's not appealable.
Which I don't think that they'll even go the interlocutory route. I think they'll go straight to a original action. That's my thought.
Michael felt pretty confident that he had ideas for a path to do that. They're very rare, far in between.
The only reason they got to go straight ahead is because she was pulling everything from the record, so they couldn't even get her to certify anything. Like, they were filing stuff, and she was just pulling it from the record, and that's why they got to, go right ahead with the OA.
That was the first
no
OA
way for them to challenge her order.
OA for Eighth Amendment violation for DOC prison. What are your thoughts on that?
I think there's something to be said with Westville, the $2.1 billion that was devoted to making a new prison, and then him being moved. And they
the public has no idea why they moved him.
Yeah, and they moved him right before the Supreme Court hearing, so it almost sort of like mooted that issue to be brought up. Because he wasn't being held by odorous guards, et cetera, just all the information they had gathered about Westville.
Well, he seems to be better off at Wabash anyway. So, I mean, that it is what it is at this point. But I guess, do you guys foresee us actually having a trial in October?
No, not if they get a original action on.
And not if there's no discovery, sanctions on the state.
All right, so can let's talk about the discovery rules here, because I think there's a lot of confusion out on the social media streets about how long the state has to give over certain evidence.
Right.
I think
30 days after arrest.
I'm pretty clear on what the prosecution has kind of stated. They're playing that dangerous game, because what they've basically said is that we're going to turn over everything because we want to make sure just in case anything's exculpatory, and then they turned over their case discovery, and then the rest of it they didn't consider exculpatory. They're still going to turn it over, but they don't consider it exculpatory, so they're not following the rules as far as the timeline of when they have to turn over literally everything else.
And law enforcement,
whenever
if they
want
got it, they can use that as we turned over everything we had, but then meanwhile Holman's got all this stuff that he hasn't handed over.
I don't think that's it. They're purposely holding back stuff, and they're really setting themselves up for a Brady violation. If anything that they've chosen to consider is not exculpatory, but they're turning it over just in case it's exculpatory. If it ends up being exculpatory, they've killed themselves.
And it's not even
completely done.
waiting for test results or something back, you know, like, and they got it late in the game. Like everything's
Right.
there.
It's
not
it's
really
not
new.
that sort of stuff. They're holding back on things that they've had for 7 years.
So anything that you guys correct me if you think that I'm incorrect in this, but in Indiana, they had the 10 days to turn over, or 10 days. They had the 30 days from arraignment to turn over anything that had to do with the probable cause affidavit.
Yes.
Then,
and they didn't even get like the video till recently. The bridge guy.
Right. Well, they didn't get Libby's phone, so
yeah.
Which is why they wanted it taken out. But then, how many days? Because that's the other thing is like people keep saying like in Indiana they have 10 days before trial to turn over all the evidence, but there's certain set rules from beginning to end. Like it's not just any evidence that they have, it's particular evidence that has to be turned over within certain time frames. I'm looking for validation, FYI. I just want somebody to tell me that I'm understanding this correctly.
Yeah, I mean, I think it's like the 30 days. I mean, for most stuff.
That's the local rule thing, and then but they keep making discovery deadlines, and then no one's following them. Or like the last one, November 1st, where they got rid of the.
Well, it's not nobody; it's the prosecution.
And then Nick goes, "I gave him everything."
Well, yeah, he says he already gave him everything,
Yeah,
but then
so,
it
like,
turns out
he
he
gets,
didn't
like,
give him everything.
And then she did set a hard discovery deadline for the contempt hearing. Remember, there was like I think Fiend put together like the best layout of what was going on in March in terms of like when the depositions were and the deadlines for discovery on the trial and for the contempt hearing. But those were the only ones that were enforced, and like any other discovery for trial is just like.
Well, I mean, that's the whole problem is that the prosecution is making their own definition for what they're turning over that needs to meet the discovery deadlines. They're still intending to turn it over, maybe, but they're clearly way beyond the deadlines. I mean, what they're talking like 7 months or 9 months or 12 months or like, what, a year or however long, like it's just going to continue. There's obviously a reason that they're sandbagging, providing some of this stuff, and it's a strategic reason.
Just hear me out, but do you think any of this can be confusion from when the old new lawyers came in and out?
Which part?
Well, so the discovery deadline for November 1st was before these lawyers were kicked off the case. She's never actually set a new discovery deadline since they put them back on the case.
She did for the contempt in March, but was there a second one or was...
I mean, with more time in this case, like I wouldn't be surprised to see another, motion for sanctions or even a contempt hearing against the prosecution. Like that wasn't like pertinent when there was going to be a trial coming up in like a week or two, but given more time, I wouldn't be surprised if the defense fires back against the prosecution for, I mean,
even on the way
they're beyond shenanigans. I mean, they're just blatantly violating rules of discovery.
And when they went to the I think it was like the phone expert depositions, that Nick prior to that said like they didn't have any data, and then on the way in like hands Rosie and Baldwin like 2.5 pages of notes.
Yep.
On the phone data. So I don't know if anybody's going to be enforcing any of this. Gull's not.
Well, that's the other thing. So at that hearing on the 7th, remember, they go into this hearing, they're supposed to be going to jury selection starting the 13th. And he's saying, like, we're still getting discovery, like, now.
And that they said that they needed 15 days in October when they had the phone call and said they were going to do the speedy trial demand. But that, like, you would think that like she's aware that they've gotten so much more since then that would only extend the amount of time that they needed, because it just keeps coming.
Well, I mean, the whole thing. D, say shenanigans one more time. The I mean, they're just changing what they like. We like when we say discovery, like we're not all talking about the same thing. Like there's multiple definitions now, because there's all they're committed to turning over everything. Like if that's what they were really committed to doing, they should have just done it following the rules of discovery, just to cover themselves in case there's anything exculpatory in there that they haven't committed a violation.
But
They made a very
that
risky move of not doing that.
That leads to other admissible discovery is discovery. So like any evidence.
I mean,
that
they don't
might
have to just
go
turn over
trial,
everything.
that
They don't
might
have to turn over
lead to
everything in this
reasonable,
investigation.
calculated, admissible evidence. So it's
They have to turn over stuff, the discovery that's related to their case, and any exculpatory discovery. And all the in between, all the in between stuff they don't have to turn over, but they're going to be held accountable if any of it turns out to be exculpatory. So they acknowledge that and say, well, we're going to turn it all over, except they didn't follow the normal discovery guideline timeline to do that. So they're still open themselves up to the exact same like repercussions. Like if anything that they haven't, I mean, maybe not as severely if they eventually turned it over, and like they ultimately did turn it over, but like anything, I don't know. At this point, I mean, I wouldn't be surprised if there's some stuff that they're not including in the case that they're holding back and purposely.
the substance they can't prove, right? Travis, like how Michael wanted to get someone to basically confirm that whatever Mullen said happened to the audio recordings isn't technologically possible, because otherwise anything substantive, like you wouldn't be able to find out if it's exculpatory till after a trial usually.
Right. So a Brady violation, what Michael has explained in the past, doesn't help you until after trial, and frequently that's too late because of the materiality requirement. You could show that something was exculpatory, should have been turned over, wasn't, but then materiality says you have to show that it would have made a difference in the outcome of the trial. So let's say there was an alibi witness and said, yeah, you know, I saw the defendant at the time that they said the murder occurred. He was in the Waterfall Bar in Quincy. And but you've got a confession and DNA at the crime scene. They're not going to find that that's material. So on the discovery, you know, Brady requires one thing: exculpatory as to guilt, innocence, or punishment witnesses. And then states frequently require more than that. Everybody that they've taken a statement from, you got to turn over the statement. They may, in Indiana, like someone was mentioning, both exculpatory evidence and also material that could lead to exculpatory. That's a grade definition, and have to look at cases that ruled on that. But so typically what happens if they, don't get this stuff produced in 10 days or 30 days, what they're supposed to? And the answer is you file a motion to compel and then ask for sanctions, which they did because of an upcoming trial date. You're asking, hey, want you to exclude this. Now, but remember, you're asking for exculpatory evidence. That's evidence that helps the defense. And so it's really hard. You can't say, well, we want you to exclude this geofencing evidence that shows our client, or more specifically, his phone wasn't in the area at the alleged time of death. For example, I don't know if that's what this stuff's going to show or not, but so you try and come up with some other sanction, and from you should dismiss the case, which is never going to happen in a case like this, to whatever it may be. And I think that's one of the pending motions, right?
Yeah, where they got kind of creative with it, in terms of not allowing Libby's cell phone information in, basically whatever they hadn't turned over.
Right.
It's not unheard of, because Lori Vallow got death taken off the table because of a discovery violation.
Yep. And they got their cases severed. That's how we ended up with 2 trials anyway.
Yeah. That's about the only sanction. But given that judges, predisposition on, rulings and the way things going, I don't think she's ever going to find that they're accountable for anything. Sadly, they didn't have a technical expert to come in and say, look, I am an expert, know everything about that particular electronic device, and the only way 10, 14, 17 days of video statements could have been overwritten on that DVR is if it was intentional. And, they just didn't have somebody to do that. And nor, some of the stuff they did say, you kind of have to be technical on some of this stuff and just kind of know how this stuff works in police stations. And that comes from, having a good private investigator and a good private investigator with you at the hearings. And your private investigator was prior law enforcement that worked in all areas of law enforcement, but towards the end of their career, worked in as an investigator in major crimes. And, they know the games that are played by law enforcement. And they would have said, look, he admitted on the stand that people would have been checking on that while they were preparing their reports. They would have gone back and looked at the videos to make sure that their summaries were accurate, or if they couldn't remember something, that they could, go back and listen to the statement and add the area they couldn't remember, or get a screenshot for a photo to put on the file jacket with that.
February to September, no one wrote a report.
Yeah.
No one wanted the video.
So I don't think they asked those questions though, right?
They didn't follow up on that.
Yeah. And so
it was more of the inference, because Baldwin comes out and says it, and he's like, if you think that a law enforcement officer is going to come out on the stand and say, hey, I destroyed this on purpose, you're out of your mind. But where he was showing sort of the inference by showing the surrounding circumstances.
Yeah. So, unfortunately, they wanted to show a few things. I think showing how the creators may have some of the stuff that came out about what he told that person who harmed himself, thought that was very telling.
Who?
But the detective that was threatening everybody.
Yeah, Holman,
Holman.
Lieutenant now. Yeah, Lieutenant Holman.
But unfortunately, I think the stuff about the creators and wanting their testimony and
that was contempt.
Was that contempt?
Yeah.
Yeah,
oh, that's earlier in the day, right?
Yeah.
Yeah, that was all Hennessy stuff.
Yeah, Baldwin handled the destruction of evidence, and so
having John Click as a witness is pretty compelling.
Yeah, oh yeah, that had to have him.
I found him very compelling on the stand. I mean, to see him in person, it was like,
oh, I wish. That sounds so amazing.
I mean, he was also staring down like,
yeah,
Ullman and Mullen, and I mean, there was a lot of tension in that courtroom.
I bet there was, but yeah, that's the thing on the discovery, and then with this thing kicked out to October, but it's going to, like they said even prior to this, given more time is just going to extend the time of the trial because both sides are going to be able to develop more information, so on and so forth. And then
if the prosecution doesn't have their case fully developed at this stage, I'm not.
They got it developed. I mean, it's pretty simple.
I don't.
All they're doing is getting more and more.
I literally have zero clue what the state's theory of the crime is at all. Not a single inkling. I mean, yeah, I can guess.
Yeah, you're not supposed to know, right? But it's pretty simple. I mean, we figured out it was his gun because we got this super duper expert that.
And we never released the scene.
and he keeps confessing. So,
well, I mean, yeah, that's all the evidence that they're intending to put on. I'm not, and then a general timeline. I would be very surprised if they're putting on like any DNA evidence or fingerprint evidence. I mean, these are all things that they clearly have all sorts of physical evidence. I don't expect them to put that on.
I feel 50-50 on all that. Because remember in the beginning, Kim Riley's like, yeah, we have fingerprints and DNA. Oh, yeah. We ran them through CODIS and it didn't come back. And like in my head, I'm like, I feel like you guys didn't collect DNA and submit it to CODIS. Like, I feel like that's not in your wheelhouse.
No, I think they did. And I think they've mentioned it as well.
But then wouldn't they do more stuff with the DNA as like time has gone on? Familial testing.
Well, I mean, I think well, I know they did talk about not wanting to do the genealogical stuff. I don't know if they ever changed their stance on that.
Or finding out Bridge Guy's height. They didn't want to pay for that.
Yeah, I mean, I don't know, but I don't think that the state hasn't indicated that they're going to put on any sort of that evidence. So, I mean, I do think that there's going to be a lot of like people that follow this case that are like, well, we're gonna wait for the answers.
Well, wait,
when you finally
Tennessee's saying that the answers in an interview to get money for experts, which I contributed generously to. He said the state's listed these kinds of experts, and we need to hire experts to address them. I mean, he went off a whole.
Yeah, the DNA they also said they had 30. They had why there's no DNA.
They also had 30 witnesses to admission and statements, and then his final witness list that he was ready to rock and roll with was going to be 40 or 45 witnesses. Like the math ain't math in here.
Well, if 5 of those are forensic people,
And to explain why there
and,
could be no
and
DNA,
5,
and it's not
you don't need chain of custody. You don't need chain of custody on statements. You need chain of custody on stuff used for forensic examination. So that suggests 4 or 5 items of forensic evidence. If he's saying what he's saying in that hearing are true, they said that there were 4 or 5 areas that they were trying to stipulate to on chain of custody, and they might have to throw in a witness or two to if they can't work out stipulations. But so chain of custody is physical evidence.
Well, we know they are questioning the chain of custody on the unspent round. 100%. They brought it up in like 7 filings now.
And the court TV airing recently where what's his name? Scorbato says that it was like 2 inches in the ground.
Labrato, Scorbato, yeah. That would be a couple names for him.
I think one of the main things, I mean, this is some speculation here, but I think one of the main like real motivations to get a different judge is to like perhaps revive the motion in limine on ballistics, because that's something that got just denied without hearing real early on, and it's something that like the facts of it aren't going to change, so you can't just like keep sending it to Judge Gull. I think if they get a different judge, they might try to be like, look, this judge admitted she was biased or recused herself or whatever. Like, can we actually get a hearing on this motion in limine on ballistics? Because typically it's very common to have the motion in limine on ballistics. That's like, that happens all the time. For it to be denied without hearing on such a fringe type of like pseudoscience, like forensics, like area is really like disconcerting. But I don't think that they could do anything about it because nothing has changed. They can't add more information of why this bullet is bullshit.
Yeah, unfortunately, if they do get a new judge, they can ask any of the prior motions and orders be reconsidered.
Right. That's why I think that's the motivation.
But they're not going to win on that. Indiana's got a terrible case by the Indiana Supreme Court. Weaker tool mark evidence than that was.
This isn't tool mark evidence.
Yeah, it is. Right?
Yeah.
No, it's not.
Yeah.
Tool mark.
Unspent round.
Because it's.
But they did a ballistic.
It's not ballistics.
He knows about it. Like they put that they tested it in the I guess in the police state lab, that they tested it by firing it, but it was an unspent round, so it doesn't really make sense. And then there's Turner restate that basically allows them to convict on the tool mark evidence.
Yeah, whether it's tool marks or ballistics, that's coming in. And then you need to go back and read that order denying the motion in limine. Because not only does it deny the motion in limine, it specifically finds that it's admissible.
So a new judge would have to look at it and say, all right, let's take this on
another judge could look at it and say, wait a minute, I can't tell you if it's admissible or not unless I know what the chain of custody is. And chain of custody,
I feel like Gull's going to let anything slide and just say it goes to the
weight.
weight.
Chain of custody typically, a long time ago, and they still teach it to forensic students, you got to be really careful with your chain of custody, because if you mess up the chain of custody, the evidence doesn't come in. Well, maybe 40 years ago, last 20, 30 years, it goes to weight, not admissibility. Means it comes in even over objection, and then the judge says, I'll allow you to cross-examine on it fully. And then, okay, well, it was 2 inches in the ground. You don't know how long it could have been there for years, yada, yada, yada. And so that's That's going to come in Indiana, unfortunately. But the judge heard nothing on the chain of custody. And even though typically it goes to weight and not admissibility, if it's found a number of days after, the circumstances under which it's found, who found it, red Solo cups. I think the person who recovered it, well, I don't even know if that's true, so I'm not even going to mention that.
Well, since we're talking about the unspent round, I have to ask you guys, how unusual is it that we spend so much time reading motions and discussing something that doesn't have to do with the murder weapon?
Oh,
Nobody talks about the actual murder weapon.
Yeah, and all the knives they got from Rick's house, obviously none of them were the murder weapon, but they could have somebody that would be able to determine what kind of bladed weapon, right, was used.
Right.
But yeah, there's nothing.
I don't know, man. I still think that we're going to find out some stuff that like has just been totally secret stuff.
I just find it very odd that we've spent, I don't know how long, talking about and reading motions about this unspent round and this gun found in his house, and nobody's shot.
Yeah. I mean, and nobody really found out about the sharp weapon till the Logan search warrant was released, right?
Watch, we're going to find out somebody got shot.
No way. There's no way that wouldn't have come out already. Not with all the locals and the families talking. I just can't.
And not with Rick Allen saying he didn't shoot anybody.
Well, he didn't. Well, he confessed to the fact that he did shoot somebody.
Maybe somebody went to a hospital with a gunshot wound.
So what is the consensus with everyone? Because I've heard different podcasters say, some say that we've heard all the evidence that's to be known, and I've heard others say, no, there's a lot more we don't know. What is your consensus, T?
Well, when the trial was going to be like 13 days long, essentially, I was like, they don't have much more to offer because the state would need more time to be able to present the experts on more actual physical evidence. So I was like, yeah, I don't think they do. And now that he's even talking, when we just read this one, that he's narrowing it down to 45 witnesses.
You know what I think is definitely his phone data. I don't know how far back they can go, but I mean, when you look at all these other cases that are popular right now, I just think I'd like to know more about the phone data of Richard Allen, number one. And number two, we have the Hoosier Heartland video, but with the FBI, so many FBI being there and everything, it seems like they could also have more video through town or, different locations, different doorbell ring, whatever.
Well, when it comes to the phone, to me, it's like, okay, if he's there from 12 to 1:30.
Stacey Diener said it's not accurate and you don't know what you're talking about.
We don't know that they have his phone from that time. Like, that's something one of the many things that we don't know.
And he has all of his phones, like all 80 of them.
No, but we don't know that he has the one that he had.
But I think we would know, right? Because the depositions that was in the Franks memo in late August when they were saying there's no digital forensics tying Rick to the crime.
Well, okay, so if he says he's there from 12 to 1:30, and we keep hearing that he's driving in from Peru, whether he was with his mother-in-law or his mother, we keep hearing different things, but the reason that he would be coming that direction, he wasn't coming from home, right? I mean, there's something with his phone, whether he takes it to the scene or not, the phone is somewhere between 12 and 1:30. It's either at his house, it's at the bridge, or it's at one of these mother-in-law's houses. It's pinging off of something. So for me, nobody's talked about that. So it's like, well, where's his alibi? And it's like, well, where's the opposite of his alibi? Like, that's the same question to me. Why wouldn't, if they can prove, he says he's there from 12 to 1:30. Well, look, we have him down in Peru at 1:10, or driving home from Peru at 1:10. We know he's not at the bridge from 12 to 1:30, or vice versa.
There's also not that many towers in the area.
No, but they would still have him coming from somewhere. They would know where he was, and they would know when he was there. Uh-oh, we lost Bean.
Uh-oh.
StreamYard hates me. Okay, let me get you the link, Fiend. Hold on.
And I mean, and he says he was there, looking at stock tickers. It would show his phone being there. Like I just, that's the main thing I really want to hear, see, or know is his phone data.
But even
Because
so,
they
we're
could
talking
get
like the phone towers. His phone records would show where he was. So even if they just pull his phone records, even if he doesn't have the phone anymore, we've now seen for sure, looking at the Carrot and Reed case, they absolutely can pull phone data from
Yeah.
a phone service provider that would
It
show that he
depends.
was
They don't
not in
keep all of
Delphi.
it that long. Different carriers only will hold on to certain information and for limited periods of time.
That's what I was wondering is how far back they could test.
But,
But
gotta
geofencing,
be
they
something.
should be able to, right?
Well, Nick doesn't even want the geofencing to be a topic of conversation.
Oh, 100%. But I mean, like in terms of, because any phone data that's been going on is going to be discovered by the defense. It's like it's being developed by the defense. Like it's never been developed by the state, or we'd know about it.
I think that we would know about it on either side at this point. Like, I just don't think there's, so like to answer your question, ultimately, I don't think there's a lot. I don't think we're going to have a jaw dropper. I think there may be information that comes out like from people's interviews and things like that on like maybe bits of information we weren't aware of, but I just don't think we're going to have any jaw dropping surprises come trial. I think what we see for the most part is going to be the evidence that they have. I don't think they're going to be like, well, nope, look we found the knife.
I mean, I
only
partially
thing that-
disagree. I think there's going to be some jaw droppers, but I don't think that they're going to be like determinative. Like, I think they're going to be things that like we just didn't know, nobody knew. But I don't think it's going to be like there's some like smoking gun evidence or anything on either side.
I would be
That's
surprised
not the
if
type
there
of
is
stuff
a
that I
surprise
think.
Information.
witness.
I just don't think anything explosive. I just don't think we're going to be like, holy shit. They have Richard Allen's fingerprints at the scene on the girl.
I don't think it's going to be that. I think there's going to be something.
I think there's going to be a witness
stuff.
that could be thrown into the mix.
An eyewitness is garbage.
I know, but like just based on the track record and what's going on, it's like that's the only thing I could see like at the last minute, like getting thrown in case things are going really, really awry at that point, which they already are, but to sort of, bring together the whole, oh yeah, there's multiple actors, et cetera, et cetera. And so if there's any sort of like holes in their case, they could sort of tie it together with some random witness. You know what I mean?
Right. All right. Hold on. Lynn said the search warrant and Libby's phone. To me, whether those come in or don't come in, I think it doesn't change my opinion. I don't think that they're going to. I don't think that the search warrant. I don't think the Franks will work to get rid of the search warrant because ultimately, if you take away the things that even if Liggett was misinformed and he writes this and he puts this stuff in there and you take it all away, I don't see that Judge Diener would have still signed it no matter what. That's my opinion of
the bar
that.
is still so low, but they still like it's. I guess it's unfortunate that they just can keep lying and nothing happens. You know what I mean? Like you could have like Franks and like she needs to have a hearing even if she denies it. But even after the fact, like nothing happens that law enforcement lied.
Right.
It's no big deal.
Right. And I just think like with Libby's phone, if that was concrete evidence that proved anything one way or the other, my opinion's always been we would have already known who did it then, number one. Yeah. But ultimately, all the defense is doing by requesting for that not to be there. And I know there's people who are like, why don't they want that in there? There must be something incriminating. I absolutely disagree. They put that in a motion to prove that Nick McClelland and his team are not following the rules of discovery. And it's not and so throw it out because guess what? You didn't do what you're supposed to do, which is technically what the defense attorneys are literally there for, is to make sure that their defendant, guilty or not, has his rights intact. And the rules of discovery for the state of Indiana encompasses what the prosecution is supposed to be doing. And if they're not, it's problematic and they should be held accountable for it. I don't think the defense gives two shits if Libby's phone comes in. Because if Libby's phone was the end all be all, it wouldn't have taken 5.5 years to get an arrest in this case.
They were
So
just
that's where
trying
I'm
to
at.
come up with specific sort of like sanctions to fit the crime, so to speak, like the withholding of the evidence, like, and having the sanction sort of apply in that regard to the discovery.
Right.
I mean, I think there absolutely should be sanctions. But T, to speak to a little bit of what you're saying there, like, I mean, I can imagine a lot of scenarios where, you know, there still wouldn't have been an arrest, even if, like, there's just a lot of scenarios. Like, what if somebody's already incarcerated and they know that person's involved, but they know somebody else is involved, and then they continue to work the case? Or they know somebody's involved, but they're deceased, but they really think somebody else is involved, so they continue to work the case. I mean, I think those are like totally plausible scenarios that they
I don't think I'm at the point where I don't think they think anybody else is actually involved in the crime. I think that their whole other people had to do with like his wife and his family members, because they go to talk to her on the 18th alone. And I feel like there's something there, like, hey, you know, like we're going to get on this. And then he goes and fights with Holman on the 26th. Like, what you did to my wife, like, you're essentially like, that was fucked up. Like, you shouldn't have done that to my wife. And I think that they were going to try to like hold her accountable for like knowing something or lying about the alibi or anything like that.
I think that's compelling, but still very speculative. So, like, I mean,
of course, that's just my opinion. That's just how
I mean, I've heard people say that too. And I mean, I think that like that is a bit of a compelling narrative, like possibly. I'm not. I think it's. I know that I probably really disagree with you as far as like your two possible theories. Like, I think that if Richard Allen is involved, like it's almost like him by himself is probably lowest on my list of possibilities.
It's so funny.
I think him being involved with somebody else is highly, highly more likely.
See, and I think if it's him, I think he did it alone.
Yeah.
I think he did it alone, and I don't think he's told a single soul about it.
But then at the same time, like, I wish that we could find out more information about, because, you know, however it was in his 40s to have a double homicide, you know, there's no progression, I guess, like of whoever's, whoever committed these murders, like that has done something similar or sort of building up their entire life. And everyone's like, well, we would know about stuff like this. But if you think about it, like they kept this a secret. So like, think about how many other maybe similar things have gone on in surrounding areas, like murders. And like, we don't know about any of this info because the cops don't want to release it. Like that people were killed in weird ways and, you know, staging and stuff like that. So it makes it difficult to, I guess, to sort of pin it to him, but there might be information that.
So for me, like, and Julie just said it too, like we know that BG had a gun. I don't question that there's a gun involved. Nobody's able to prove to me that Richard Allen is BG. I have no issue with BG being the person.
We don't know that BG had a gun. This is another thing where we're jumping to some conclusions, like we just can't make.
We hear it in the video apparently, but I don't until we hear it.
You know, you maybe hear it on the audio, but you don't know the audio is connected to the video. Like, I mean, just based on what you've seen of BG, you can't tell who it is, and you can't tell that he has a gun. Period. Neither of those things are possibly true.
It's just to link the gun, the bullet at the scene.
I think that and if you look at the way that the defense has reacted to a lot of things, I mean, that's what they're fighting against, because that's where the case is being made. Like that they see the writing on the wall as far as what the prosecution is going to be putting forward, and a lot of it relies on matching the cartridge to the gun. matching
Yeah.
the gun to Richard Allen. So, like,
Yeah.
you know, they're attacking those points.
Well, this comes down to the whole thing of like, what do you trust? Who do you trust? What do you trust? And we're looking
Well,
at.
I think there's a lot of
right now we
evidence.
only have court filings.
There's a lot of evidence to not trust what the state has said.
You're right.
anytime
That's why I'm going to give you that one. I will agree, because we don't have it to know for sure, and that's a trust thing just because it's written in a document.
Well,
And
the state also hasn't made these like definitive statements. They haven't said 100% the guy on the audio is the guy on the video. You know, they're very cagey about making any definitive statements, and they always have been and still are. Like, only very, very recently is there just one like statement or quasi statement that Richard Allen is even bridge guy. Like, that's just really recent that they've gone that far, because
Right.
they've said that before.
well, they consistently said at the beginning that we will not say that we know for sure that that person is the person who committed the crimes. They
Right.
would not commit to that whatsoever at all.
They
Now
do.
and now you have Carter saying that, yeah, Richard Allen is bridge guy.
And they changed the charges.
The
Sort
charges
of.
made more sense to be. I always had an issue with the way he was charged at first.
Well,
the charges
yeah.
actually make more sense. So that's one thing I do give Nick when he's like, yeah, we don't have a new PCA because the charges actually do match what we originally should have charged him with. That was just Nick not knowing what the fuck he was charging with.
I disagree on that too. With given the opportunity to rewrite the PCA, they 100% should have rewritten the PCA.
It was just a tactic when they knew the lawyers were coming back. Remember, Nick did it like 10 minutes before the
Right.
Supreme Court hearing.
Yes, I agree. That's 100% what it was, and it doesn't make any sense. And a lot of it's
Be
bullshit.
enough time till October for the defense to be able to work with these new charges.
The statute of limitations on the kidnapping charge doesn't apply. That was BS. They just didn't want that's a tactic to not.
I don't mean the kidnapping charges. I mean charging him with the murder and the felony murder.
Like, there's no reason to charge if you charge there's no reason to charge somebody with felony murder if you're charging them with murder.
Well,
there's zero.
They can get one or the other. Maybe they feel like if they can't prove one, they can at least prove the other.
But now that, people are circulating, I heard it on here first from UT that, like, who killed the girls? Like, once we get through this trial and we're only charging him on kidnapping, then who killed the girls? And I think that that's really sort of, livened everybody's like reality of like, oh crap, that's not who killed the girls then.
But that is still the case because there's felony murder still there.
But now it's murder too. So
if he's not the killer, then who's the actual killer?
Well, if it's him, he's the killer. That's, I think, why.
Well, then that's what I'm saying. The felony murder doesn't apply. It's not relevant at all. There's no way for that to be relevant.
It is if they feel like they can only prove the felony murder. Yeah. But if they can prove both, then that's better.
Well, you can't prove both. Like, but yeah, if it's only like. If it's the murder, it's the murder. And if it's the felony murder, then he's not the killer.
No, not necessarily. He could still be the killer.
No.
It would not be an intention to kill. He could still be the killer. The felony murder is that he kidnapped them and it results in their death.
The intent to kill. That's not... there's the stabbing victims. There's no way that there's like it was an accident that they just happened to die in the process of something.
No, I think that's where the gun comes into play, is the kidnapping. So he took them under duress, kidnaps them, and then ultimately he ends up killing them.
But then that's just regular murder. There's nothing felony murder about that scenario.
It is, because his intention was to kidnap them and
the intention doesn't matter.
It does.
Yeah, it does in the charging.
It doesn't. That's not the distinction. Like, it's not for like a first degree murder and a second degree murder sort of thing. They're completely different.
What's the accomplice thing? Like the accomplice murder?
And then there's the accomplice liability attached to both of these charges, all these charges.
That's the one that gets me. That's the one that I'm like, okay, why is that there? And that was not
all
there
of it
before.
indicates that if it was straightforward that he's the killer, then it's just a murder charge.
The only reason I see accomplice is if they like at the last minute like pull somebody in to sort of say, something incriminating about Rick more than that is, I guess, already known. Because with the accomplice, like you don't even have you prove like you were going to meet somebody or you set up a meeting for somebody else. Like you can be so far removed. And then the person that's saying that you're involved basically doesn't have to be charged for it or anything.
I mean, is Travis still here? I mean, Travis would be able to speak to the I mean, there's not, as far as I understand, it doesn't make sense. If you're the killer, you're the killer. There's no way that the felony murder applies in that scenario. Felony murder applies to you do something and it ends up happening that someone dies, and so then they tag you with a felony murder charge, and you aren't the actual killer. You may have been committing a burglary, you may have been committing a kidnapping, you may have been doing it like you may have been just participating in a burglary or a kidnapping, and someone ends up dying and they tag you with a murder charge on it. Then like it happens very commonly. Like they way overcharge people in Indiana and tag them with these felony murder charges, and it's very similar to a murder charge, but you didn't actually do the killing. If they're saying he's the one doing the actual killing, then that other scenario, like it's working against them because it's either one or the other.
Fiend, or not Fiend, Travis, what do you think? Are you still listening? I know you're still up here.
Slick Nick.
He may have walked away.
He's eating dinner. I don't know. It's just very different state to state because we're very used to like watching these types of like cases and like there's murder 1 and murder 2 and like it's just not a thing in Indiana.
Yeah, and I hate Indiana because it doesn't have that. It's a pain in the ass.
Yeah, so the intent isn't the thing. Like the felony murder is just you committed a crime and someone ended up dying, and we want to hammer you for that happening. And sometimes that could be like warranted, often it isn't. They get a lot of kids involved in a crime and someone ends up dying, and it doesn't matter like who it is. It could be like their accomplice on a crime that ends up getting killed, like someone kills them in self-defense, but they tag that person with a felony murder charge and then lock them away forever. And it happens all the time. That's usually the type of scenario that it's like more applicable. Like this scenario doesn't make sense unless you're really talking about some sort of accomplice or like multiple party scenario. And it always didn't make sense right when they initially charged it. The felony murder was a weird charge.
If you look into Keegan Klein, and I don't think that they're related in the sense that like they committed the murder together or know each other or anything like that. But when you look at him pleading out and like you can tie in like the Wabash River, like maybe like they were pressing him up until then, but there's some weird similar circumstances where Keegan Klein gets rid of one of his lawyers without, like the lawyer doesn't want to leave, but he gets pushed out and then a new lawyer comes in and then he finally decides to take the plea deal. So in terms of, I guess,
well, he didn't take a plea deal. He pled guilty.
No, I know, but he still got less.
No, he didn't get less. He probably got more than anybody has ever gotten in the history of the state.
But they kept
postponing. They dropped like 5 charges that they were like,
exactly. But still, like they kept postponing it for like months and months and months, and then like finally they switched his lawyers, and then he decided like to plead guilty and let it be done.
I think he's not very smart and made a terrible decision as far as everything that he did. He got hammered worse than anybody has ever gotten hammered.
Well, they
Yeah,
needed to make an example out of him.
Yeah, and because high profile, and that's exactly what they did.
Yeah.
And I would argue that they probably did make a good example of him.
Well, I think also at that time, they were really pushing that he had something to do with the Delphi murders. And I think that they were thinking, like, if we're going to offer you this, maybe you'll come back with some info that will help us. Because I definitely do think that they were pushing for him to be BG or part of it, or his dad or whatever. You know, he was a part of the whole thing with the Dropbox and everything else. And when it wasn't working out for them, then they had to switch gears and they had to go, quote unquote, back to the beginning like they do. You know, which is the same that they did after Ron Logan. You know, they couldn't get him to cave to being the person, and then they couldn't get Keegan. So I think that was also part of their deal, was like, let's say we're going to give you this is your plea, and he'll be like, all right, I'll give you info that you want, cut it down to whatever. But he didn't have any valid info, so he got what he got.
I mean, the specifics of his crimes are pretty terrible, but
he's a garbage human being. I'm not going to disagree with
right.
that. I do have a problem with the fact that I once again, like I said with Ron Logan, they did the same thing. They focused on this person, and that was the person they were going to make it be.
They took his dentures and all kinds of torture.
So I think they were
That's
still,
why I think
they had the outskirts still looking on other people, but you know, and the FBI was really focused on Logan, and they essentially said Keegan Kline had nothing to do with it. They went investigated him and said, yeah, he's got nothing to do with it. We're not going to spend our time on him. We're going back to Ron Logan over here. And the FBI goes away, and now they're back to Keegan Kline. You know what I mean?
Sort of, but I mean, I don't know that the FBI was like super laser focused on Ron Logan. There was a lot. I mean, I wish that we could see like some of these warrants that were issued, and honestly, it might solve like some of the Frank's issue a lot, because some of the information that, like, you know, the defense says wasn't disclosed to the judge, so they wouldn't have been able to make this decision. Oh, some of that information totally could have been disclosed to the judge in previous warrants. Like, they could have told the judge. I mean, they could have told Diener all about Brad Holder like a dozen times, because that's how many warrants they served. He may have been well aware of these things, and they didn't leave it out. The judge just already knew about it. That's a completely fine scenario. There's nothing wrong with that. But we don't know. But like, they were also serving these warrants all over the places against all different houses and parties, and like, clearly there wasn't probable cause against all of these people, because
they weren't
involved.
I think that a lot of those, like, it's I guess, yeah, like you're saying, like knowing the warrants that were actually executed, and then it feels like over time, whenever like the investigation went a certain way, then like someone would come out and be like, I was just like interviewed like 8 times and interrogated, and I gave my blood and took a lie detector, and like, you should do it too. So it's weird like that.
It's Royal Wee's statement on here. Has anyone seen Diener's signature on the DCA?
Nope.
Nope. It's still nobody has seen it.
Well, back to all the search warrants with probable cause. I mean, they had search warrants to search the phones of Patrick Westfall, Brad Holder. They didn't execute them. Right.
That's one of the biggest things that, like, is a takeaway for me, because they weren't shy about executing these warrants about anybody and everybody, like, and people that probably clearly weren't involved at all. They didn't care. They didn't care about the Fourth Amendment rights of like the people of Delphi. They were just like, we're coming in, we're gonna look through your shit, because you might like, and you know, the judge was signing off on all of it, and we haven't seen any of these warrants. And like, you know, at least one household that pushed back and was like, wasn't happy about it. So what's different when it's Brad Holder and Patrick Westfall, where you're like, well, these warrants we're not gonna, like, we wrote them all up. We've got the probable cause.
Hold on, I gotta address Lynn real quick. They did have search warrants. They had active search warrants to get information from them, and I don't know why you guys all think that they had solid alibis. They didn't. Patrick Westfall
No,
even
they
said they
didn't.
didn't have a solid alibi, that he was just at home. And everybody was like, oh, he could be at home, and everybody says that's not a good alibi, but if Richard Allen was at home, that's supposedly a good alibi. So that's problematic. Two, they did have probable cause. They had the search warrants were already signed. They were just not executed. Second, Brad Holder, all they did was call, and then they were told that there was a video. You could get the video to see him leaving and coming from work. Nobody went and got the video. So nobody
Or looked at the video.
That's the problem I have
No,
with law.
yeah, there was hypothetically a video that might
Yeah,
have
like
shown
the
that,
person on the other end of the line said they clocked in, but they didn't actually check the video.
they just try to check
Right.
they don't just check the clock in records and I mean I don't know. I mean I
But
know
how
when
pissed
I-
would you be
when-
if, let's say you're Brad Holder and you know that they could have done all this and you wouldn't be dealing with this shit 7 years later? How pissed off would you be?
well if you're not
like Karen
If
Reed.
you're not involved. Yeah, if you
Um,
actually aren't involved. Like I that's what I
well,
think of. And when I think of like them doing this deposition with him at the beginning of May, I think like that's where I would be at.
They also, the person that they sent to check on his alibi didn't check on it and also was a buddy. So that's not great. Not a great situation. Because, gee, I wonder why it didn't get checked out very well. You got a family friend coming to check you out. And he's like, no, you're fine. Don't want any trouble. You're good.
Right. I think that's going to end up being, and it kind of goes like the same with the Karen Reed stuff, is these people that are quote unquote this third party. It's the lack of investigation into them to be able to prove that they weren't doing any of these things, and that's how I feel about this. It's the same thing. Like if you had the opportunity, and Doug Carter's literally calling Brad Holder a suspect, why are they not following up with it?
If some of this doesn't go away, though, like if Brad Holder is physically at work with other people on that day,
right,
that can vouch like, yeah, I was there on the same day with
Well,
Brad
we
Holder.
don't really know the time of
He
the
was
murder.
at work that day. That person doesn't just disappear. That person still exists. Where is that alibi? It still doesn't exist. The alibi doesn't exist. Like,
right.
I mean,
Well, so we have this random new phone download. I'm very curious if it's Brad Holder's.
I mean, I heard Mark Frost speculate that it probably was.
I'm just thinking like he's showing up.
That's the one that's
showing up for hearings. He's now doing these depositions. He's probably like, listen, I wasn't there. I had nothing to do with it. Here's my phone. You can see everywhere I was or anything I did. Here's the phone I had at the time.
Yeah, but is it like West Falls where it's got like 2 days of records on it?
Well, yeah,
right.
Patrick Westfall, and he's still throwing Patrick Westfall under the bus.
Exactly.
Yeah, I mean, you can't roll that back. I mean, he already said that, and it's documented. So I don't know. I mean, and I've heard like it's speculation as well, as far as like people that are more pro prosecution, that that them tying the more recent deposition of Brad Holder, where that Abby was at Patrick Westfall's house, like that makes makes the nexus and opens the door to really go this direction.
True.
Because now you've connected it. Just you got that final link where it's like,
and
that's
you got
probably enough.
Who's Becky Patty says you should check out Holder, right? She tells Purdy.
Yeah, according to the Franks memorandum, that's the first time that. I mean, it obviously wasn't the first time, because they said that they contacted Brad Holder the 13th.
That's one of the missing interviews,
which is insane. Like the 13th, like
they didn't do anything that day.
And I mean, or I'm pretty sure that's what it was. But like, yeah, they're in contact with Brad Holder almost immediately after this crime occurs. And Judge Gull, like, really, like, I think she really screwed up on the way she ruled on the first motion to to dismiss, because her reasoning doesn't go further than saying, well, Brad Holder wasn't a suspect and Patrick Wessel wasn't a suspect, and like that you need
Rule
to go
number
a lot
one,
deeper
everyone's
than
a
that. That's setting things up very poorly when it becomes clear and they have receipts that everybody acknowledged that they were definitely like key suspects.
Yeah, I don't think that her putting in the order, like she seemed to really go out of her way to put their names and like clear them publicly, you know, like in the order,
Yeah,
as opposed to ruling on the motion to dismiss.
Right. I think that was a huge error, whichever side of it, whether you think Rick Allen is guilty or not, like, or even more so. I mean, that's the most of the things that are like where you I would harp on law enforcement and the judge in this situation. I think they're worse from a pro prosecution stance. You don't hear it from a pro prosecution stance because it appears that like things are going quote unquote your way, but like they're not. They're bad. These are bad things to have happened. Like they're really tanking the whole situation. Like these are the exact things you do not want to do to have a clean conviction on somebody.
And it all kind of goes back to, like, I still can't believe that Gull got rid of the attorneys based on like what we know now from the contempt proceeding, like what was investigated during that period of time where, you know, she was going to arrest everybody. Like where
Right.
nobody even had any conclusive information on anything. I mean, Mullen didn't even see the email that was sent.
If you don't meet the bar for contempt, how the hell do you meet the bar to disqualify somebody? That doesn't make any sense.
But that they didn't even have like one tiny piece of concrete information.
No, it was all silly stuff from YouTubers.
What a surprise. I mean, we had 6 years of that, and we still have it, even though there is an arrest. And it's interesting because there's still stuff put out today about information that has no validity on both sides. And yet it's still like that's just how it goes. I don't know. This case, I'm frustrated because I think I was ready for the trial because I was like, okay, we're going to get some answers. Like, even if they're not the answers we want or we think, at least we're going to have some answers. And now it's like, I feel like it got pushed back out, and it just gave like so much fuel to the fire, I guess, on this whole, see, the defense does this and the defense does that, and the defense. I don't know. I struggle with that because I'm like, I see them working to try to defend this person, whether I think he's innocent or guilty, irrelevant. I feel like she's just not allowing them any leeway to be able to put on a defense for their client. And I don't know if it's just the lack of communication or if it's just the animosity and the bias. I don't know what causes it, but it's like, it's at this point, it's frustrating. It's frustrating because I don't see now, even with the trial, if it ends like with these players involved, I don't see that it's going to be done. And that
we can trust the justice system.
All right, so here's something to chew on. As far as I don't think that they were chewing on it the same way that like maybe different ears might chew on it. Like, but Frosty and Mark were talking about like what does it mean? You know, you've got two sets of defense teams that have claimed that he's factually innocent, and like, you know, they're speculating on, well, what does it mean when they qualify it as factually? Like, what does that mean? Well, I didn't hear them give the right answer. I mean, factually means like you think he actually didn't do it. Like, that's what that means. But like, why are they committed to saying that he's factually innocent and committed to a not guilty plea? Like, that's not really that typical. Like, to me, my interpretation is like he's not factually guilty of this crime, but like he may have involvement, or he has no involvement. But I don't think that they think that like they're just trying to, like, he's guilty, but they're just doing their job. Like, that's not what that indicates at all.
What do you think it indicates?
I mean, the two possibilities: either that like he's not charged correctly and has some involvement, but isn't particular, like specifically guilty of these crimes, or
Okay.
he has no involvement and he's just not guilty. He's just in any way, shape, or form. But like factually means like he didn't actually do it,
as opposed to the state not being able to prove beyond a reasonable doubt.
Correct.
Well, Travis, now that you're back,
Yes.
we had a question for you, but you weren't around at the time. And just an FYI, guys, I don't mean to cut it short, but I do have to go cook dinner here in a little bit so that the younger people in the household don't get really feisty and come yelling at me for food.
You can come yell at us and kick me out the door anytime. Don't worry.
But I want to know, so Travis, about the charge. Fiend, you want to ask, because I think that the way that you had it worded was much better than the way I did.
Yeah, I guess just the question for Travis as far as the two sets of murder charges, they're charging both murder and they're charging felony murder. And
Right.
My understanding is that felony murder is more for somebody that isn't actually the killer, that commits some sort of crime that ends up with somebody being killed, and then
right,
and then to make it more complicated, there's accomplice liability to attach to all four counts. Does it make sense to charge a lone wolf killer with felony murder?
Well, yeah, because if all you need to show is that the person was in the commission of a certain felony, and in Indiana they list them. They enumerate the felonies that are subject to felony rule. So all you have to do is show that the person was in the commission of that and that somebody died. And so it could be the intended victim of the other felony, like burglary or kidnapping, or it could be a co-defendant. You accidentally shoot the getaway driver. You don't have to show any type of intent with regard to the killing. With regular murder, you have to show intentional and knowing. So not only that you intended to kill the person, that by your actions, you knew what you were going to do and you intended for what you were going to do was going to result in the death of the person, which in this type of crime is kind of self-proving circumstantially.
Right. Because they were stabbed. So like, when you stab somebody that you're killing them.
Right. And so when the
other states,
when the Indiana practitioners were on the various creator channels like Kara and that young gentleman, really nice. I think he may be running for judge.
I know Mark Lehman did the argument.
No, I'm talking that came on Bob's show and maybe this one and others, but like Kara came on.
DJ?
Can't remember his name. Anyway, it doesn't matter.
Public defender.
Yeah.
Oh, Shay Hughes.
Shane, there you go.
Yeah.
She running for judge.
Shay's not a young guy.
No, that's
He's young to me. He's young to me. So what is he, 40?
I don't know.
I don't know.
That's
Probably.
anyway, it doesn't matter. So I asked each and every one of them when they were on, I'm like, why in the hell are they doing this? Why are they seeking to amend? And because with the felony murder, you have to allege the underlying felony, which in this case was kidnapping. So you kind of had to prove the kidnapping, but that's easy to prove. Having someone travel matter of millimeters against their will is kidnapping in most states. And to move it to this other one, which, obviously that came probably at the suggestion of that attorney who Nick finally got funds to add, but it was perplexing to a lot of people. But I thought it was because they wanted to put life without parole on the table, but no one agreed with me on that, because kidnapping is also an aggravating factor that can get you, if you give notice to the court, if the prosecutor gives notice to the court timely, you can seek life without parole or the death penalty. And kidnapping is an aggravating felony that qualifies for either life without parole or the death penalty. But no one seemed to agree with me on that. And then it was moot when there was the hearing, and they agreed to dismiss the felony murder charge. Is that right?
No, they did not. No, that's the current status is that there's 2 felony murder charges.
Okay.
And 2 murder charges, all with accomplice liability. Nick, they previously didn't have the murder charges. They only had the felony murder charges and the 2 kidnapping charges, none of them with accomplice liability. And the Nick moved to dismiss the kidnapping charges. The prosecution moved to dismiss the kidnapping charges. He cited that the statute of limitations had expired, but that's completely not relevant. I mean, from what I was able to research, it's not a thing when a death is involved in a kidnapping. Like, that statute of limitations goes right out the window. You can always go back and charge that. I think that they just didn't.
Well, no, you can't charge the crime of kidnapping on its own if it's beyond the statute of limitations. What you can do, again, if kidnapping is an underlying felony for felony murder, it doesn't matter. There's no statute of limitations on murder. And so because it's procedural and not substantive, it's an enhancement. Statute of limitations don't work on enhancement. So you can use kidnapping for felony murder regardless of when it occurred. That's right. So they added kidnapping on its own, and I think they had a ridiculously short statute of limitations, 5 years, right? Yeah, 5 years.
Yeah.
And it was over 7 by the time they added it. But so they could add the murder. They could add the murder was aggravated murder in the course of kidnapping. Therefore, we want the death penalty. Therefore, we want the life without parole. But Michael, I was on a panel with Michael, and he said, nah, it's going to be life anyway. If they get a double conviction, it's essentially the max, just so everybody knows, for if it's not life without parole, the most you can get in Indiana for murder one is 60 years. But they can run consecutive. So he said they would, if they're convicted, if the defendant's convicted on both, they're looking at 120 years consecutive. So they've already got a life sentence. They don't need to complicate it all. But no, there was a lot of discussion, and I've been on panels here months ago going, why are they amending to this? Wouldn't it be much easier? And Kara didn't have a clear answer. The other gentleman, who is relatively young to me, he kind of thought about some of the options I was laying out. What wouldn't it be to get life without parole? He didn't really think so. And I don't think Michael did he, Teresa? I don't think Michael had a good, clear answer on why you would go from, why you would allege plain old felony, a plain old murder where you had to show intentional and knowing killing when you had an easier way to do it, felony murder.
I think there was twofold. It was preemptive because he filed it like 10 minutes before the oral arguments at the Supreme Court. So
right.
Sort of knowing that the defense was going to be coming back on, because the last page of the amended charges that he filed, he says, like, this should be enough time for the defense to be able to, adjust with these charges because it's 9 months away. Like, our court date is not until October, like when the trial was, when it got reset too. So it was sort of solidifying that. But also I think like the word got around on the internet, streets, and then like into, regular population of people being like, wait, so if they convict him of the kidnapping and the murder, then like who killed the girls? Like they don't have to prove who killed the girls. And I think that became a problem. Like people being aware of that.
Huh, really?
I mean, I think that they had to be aware of this, like, previously.
No, I'm like the general population. Like, I don't think people like, were making that, conclusion in their minds.
Well, I still don't think people are making the conclusion in their minds, because that's what I'm saying with, like, this is the part that doesn't really make sense. It's like, if you're proving the felony murder, you're kind of disproving the murder. And if you're disproving the murder, you're disproving the felony murder. Like your state's getting very like wishy-washy on like what's their actual theory here. Is he the killer or is he not the killer? And
but it's all about
even at this, and as we stand here today, in our filing they did not put that he was the killer. They said, and they even went so far as they said he was quote unquote bridge guy, which is like a very weird thing for them to say, because
they're used to public perception being everything.
Right. But
Going to see the trial,
type of like definition there, calling him bridge guy, but they hadn't even gone that far. But like they've still not said, look, Richard Allen stabbed these kids. Like they've never said that. They've never said that once.
They hide behind the gag order.
Well, I mean, it would be normally it would be something like one of the very basic information that you would put in a probable cause affidavit that the defendant stabbed them, like, and killed them, like, and that's very basic piece of information.
That they would have a confession that actually, like if someone confesses, we want to have all the details secret, and that was their reasoning, and then. We have these confessions that, he shot them.
Well, the best explanation I ever heard for it was during one of Teresa's lives, and I can't remember the particulars. Maybe she can, but if you went through logically just a logical step-by-step analysis, what the elements were for felony murder in Indiana and what the elements were for regular murder. There was one bizarre hypothetical circumstance that if a jury got hung up on, well, I don't think he's bridge guy. I don't, so therefore he's not involved in the kidnapping, but I believe he's involved in the murder. You could have this bizarre situation where and juries never ever do this. I mean, it's like law school exam stuff, but you'd have this bizarre situation where they believe the state proved beyond a reasonable doubt that he murdered the two victims, but he wasn't involved in the underlying predicate felony kidnapping, and therefore he'd go free, which is why people suspected they tried to add the kidnapping. That gets rid of that problem. And if they, they have that, they can find that. And then if he's not, they don't believe he was part of the murder, all he did was part of the kidnapping, they'd have him on that. Plus they'd have him on the felony murder. But it was really, it was really convoluted stuff. Teresa, do you remember, that's kind of what I remember is somebody pointed out, might even have been you, Teresa, that, well, kind of working through it. Well, wouldn't they want to do that if, for example, they couldn't prove this? And
well, that's kind of where I still am with it. I think that when the charges were just the felony kidnapping, I was like, they didn't make sense because the public is still going to have this quote unquote bloodlust for whoever actually killed the girls. Because if they could only prove the kidnapping that led to the murder, then people are still going to have that question and it's not going to shut anything down. So I always wondered why they didn't just go for the murder. Well, now when they changed it, my thought is that they're trying to cover the basis of what they can get a jury to believe. So they don't care necessarily if they pick one or the other, but they would prefer both to go with having, consecutive sentences. And then he's going away.
His second chair, it's been around the block. I don't think they're doing, in terms of amending the indictment, amending the charges, I don't think they're doing anything for public perception or jail population perception, media perception. They're doing it for one and only one thing, and that's jury perception,
right.
And not trying to avoid the rare instance where if you don't charge something properly, where you have aggravating circumstances. For example, a third DWI is a felony DWI, DUI, OWI, whatever you call it in your state. The predicate for that is you have to prove 2 prior DWIs. And if you don't do that properly, and you're in felony court, the only choice for the jury is to acquit if the state hadn't properly proved the 2 priors. They, absolutely convinced you're drunk on your third. And so with these aggravating things, the state tends to be very, very careful on how they allege that, because there are plenty of cases, they're usually 50, 60, 70 years old, where the state didn't catch to the fact that a jury could find a person beyond a reasonable doubt under certain elements, but because the way they had it charged doesn't result in a guilty verdict under either charge because of an aggravating circumstance. But on this, so Bridge guy, let's say hypothetically, it's a clean video. They have a Apple, whatever. I don't know what I have, but I mean, it's damn good video. The latest Apple. They have an Apple and it's in 1080. Forget that. It's in 8K HD. It's clear who it is. The audio's clear who it is. And whatever he says, okay, girls, down the hill. That person, it's not going to take a jury much at all to find that beyond a reasonable doubt, that person committed kidnapping. Then what do you think, I mean, and then if that person, and I realize that's not the facts in this case, but let's just say hypothetically, because that's the first thing that they got to get. The state's got to get the jury to believe beyond a reasonable doubt. So let's say this fictional hypothetical case, they've got that on video. I mean, it's just really, from the state's perspective, they're not going to have to show too much more that person is involved in the murder of the two hypothetical victims, are they? I mean, a phone call to a relative, not going to be that hard to prove. In other words, looking at it from the other way. So he gets convicted, but kidnapping's out, but they convict him just on felony murder. 2 people died in the course of the person committing kidnapping. Say the state didn't add this other charge. They play recordings in front of the jury. The media covers that. Maybe something linking, found at the scene, linked to this person's home. Maybe not a gun, but maybe a handle of a knife. And there's a knife at this hypothetical defendant's home that's missing half a handle. Maybe same footprints or something, whatever, some corroboration. Do you really think that the public's going to be always wondering, they clearly committed the kidnapping, but we're not so sure on the murder? I mean, I'm trying to understand where the disconnect would be. But I'm not aware of all of the facts and all of the problems and the lies and the, stuff that you guys are. But I'm just telling you, the people of that county and the people of Indiana, exactly like the Avery case.
Yeah.
Well, the people in the county aren't the ones on the jury. And this is, if we're going to talk about hypotheticals of we get the legal, some of the legal stuff, but the theory stuff, the theory of what actually happened. You can easily have a felony murder charge in a lone wolf case. You can have somebody kidnap somebody off a bridge and the kids fall off the bridge. You didn't mean for it to happen, but they died. So it's a felony murder. It's a completely different situation. Involving
that's
a
exactly
deadly
right.
weapon. When you stab people or you shoot people, that's not the same sort of situation at all.
But it's about what you have to prove in court.
That's just
and
murder.
What you don't need to prove in order for the charges to.
So let me try to put it like this. This is kind of, I think, how my brain interprets the 2 charges. We talked about before that this BG video is essentially garbage, right? I mean, they can't actually tell who it is. So if they go with the felony kidnapping that leads, felony murder, with the kidnapping, let's say they think they can prove to a jury that Richard Allen is Bridge Guy and that Bridge Guy kidnapped the girls. But let's say the jury doesn't believe that Richard Allen actually takes the girls across the creek and kills them. Let's say they don't believe that. Well, then we could still get him on the kidnapping, on the felony murder with the kidnapping.
Right.
Now let's say we can get the jury to believe, because of the unspent round, that Richard Allen is actually the one who committed the murders. But we cannot prove to the jury that Richard Allen is actually Bridge Guy.
I mean,
Exactly.
that's the point I'm trying to make, T. Is those are two competing theories of what happened.
I agree with you. We do agree then. My point is that they're trying to get either or.
They're hurting.
No, it's not really competing. It's just so in the closing argument, it's like this.
It's reasonable doubt because it's reasonable doubt against the other.
No, it's an alternative argument, and so that's why you have both charges. So it goes like this: they put on the evidence, whatever, and then they get up and they argue. Look, we think the evidence shows beyond a reasonable doubt that this defendant is Bridge Guy. Therefore, he committed a kidnapping, and then 2 people died. And so we don't have to show what his intent was. The people he clearly kidnapped on that video ended up deceased. That's felony murder. But even if you don't believe we proved that he committed kidnapping, that he's not Bridge Guy, if you look at count 2 that the judge just instructed you on, if you find that he was involved in the actual murder because of the bullet, you can disregard that and you can find he's guilty of murder on that basis. Now here's the kicker. Here's the kicker. Wait for the punchline. They get to argue, and you guys have seen this in recent cases. That's alternate counts, ladies and gentlemen. So if 4 of you think he's guilty of murder under theory 1, and 8 of you think he's guilty under theory 2, your verdict's guilty. That's the old Chief case, by the way. And that was argued in the trial against the young lady in New Mexico, and another trial recently in closing argument where they said, you don't all have to agree on your verdict. Some of you can decide it was under this means, some of you can decide under this means. Now, it depends on the pleading rules and laws in Indiana, whether that's true or not. It may be that they've got to be unanimous on one or both.
That's wild.
I think they do. I think that I get what you're saying, and like I think that that's like not the bad strategy if there isn't a third party defense. I think that
there's not going to be a third party defense in this, but there are going to be plenty of.
You think it's impossible that they
she ain't going to allow that in.
That anybody other than Richard Allen is involved.
Yeah, writing's on the wall, but it doesn't matter. Just like in Karen Reed case, third party's not in that either. But
in Karen Reed, though, it is.
Basically is.
No, well,
it basically is because it's the investigation and bias and motive.
Well, no, I mean, it's like halfway. It's in progress.
It's developing. He's allowing them to develop it through cross-examination,
right. And that's no different at all than this destruction of evidence.
Or how about McClellan's motion?
Well, we know that it's not going to be completely ignored, likely in this case. I can't imagine that that's the scenario. I think maybe it's similar to like the Karen Reed case, but
yeah.
Even if it's not, if there's if there's zero mention that anybody else could possibly be involved, then yeah, that's a great strategy to charge both, and the jury can land where they land. Like if you otherwise, like the prosecution seems to be making an error as far as like really opening up some reasonable doubt of who is the killer, and
Right.
is this other competing theory more compelling? Because the prosecution is saying it could be a different person that killed them, and the defense is saying a different person could have killed them. Like maybe that's the most compelling theory of like what actually happened here.
No, 'cause
Right.
it doesn't get argued that way. He's the killer under both counts. Under one, we don't have to show under the first count. We don't need to show.
One at a time. I can't hear you.
Yeah, it's not competing. Okay, it's under first. He's the killer. This guy right over here killed these girls in our community. This son of a bitch right over here. Under the state's first charge, if you find that he ordered them down the hill, that's kidnapping, and you find that they're deceased, and you heard the medical examiner come in, he's guilty beyond a reasonable doubt under charge 1. Under charge 2, he's the murderer. If you don't, even if you don't find that he is the person that ordered them down the hill, he's the person that killed them, and we know that because of this physical evidence and these.
Travis, they were stabbed. Like either the person who stabbed them is the killer. Like there's not there's not like a way for them to accidentally die.
Yeah, I get that, but they're not competing, okay, and they're not going to be argued as competing, and the jury isn't going to have to go, oh my gosh, well, they're saying it's this, but then they're saying it's that. It's not going to be like that. It's pretty simple. Look, if we've proven to you that he kidnapped them and they're deceased, we win on felony murder. If you have some doubt on felony murder, we still win because he's confessed and there's corroborating evidence, and he's still confessing. I mean, he's confessing as late. That's what they're going to argue. Now, I'm not saying that those confessions or whatever, or that the corroborating evidence which is the unfired shell casing, are going to be proof beyond a reasonable doubt. But those are the arguments. They're not competing. They're not creating.
I mean, I disagree that there's some competition as far as like either Richard Allen stabbed them or somebody else stabbed them. Like those are two competing theories. Maybe not legally, but like as far as factually as what actually happened, those are competing ideas of what actually happened. But let me ask you this. What do you think of? Well, now I forgot
but why is it conflicting that the person who stabbed them also ordered them down the hill?
It's not. That's not. But all of that is just that. All that's murder. That all of that is just regular murder. None of that is felony murder. Because it's a murder by a deadly weapon. Whoever is wielding the deadly weapon is the killer. And
I mean, there's no question. Yeah, no question that the second charge. Now, what we may find is they're just going to wait and see how the evidence comes in, and either the state on its own motion or maybe the defense files a motion to dismiss when the state closes, saying, Judge, there's no evidence whatsoever that, and so one of those charges disappears. I mean, that happens all the time. But you're right.
So that's what I'm saying. Like, I think the prosecution would have a much stronger case if they dropped the felony murder charges, like, and they just stuck with murder, because there's much there's no conflict. Like, you're clear that he's the killer.
Yeah. Well, except you got to show intent. But if you have two young girls,
But Travis, that's it's probably different in other states. But like the use of a weapon is intent in Indiana. That you like, if you shoot somebody, you're like, it's assumed that there's no murder one and murder two. That it's murder.
right? There's a presumption, a rebuttable presumption, and it's really difficult, especially in a case like that. I don't know. Could be they're worried that, like Teresa was saying earlier, and it's ironic that we never discussed the true murder weapon. Maybe they were afraid of that. I don't know.
I mean, it is weird. It's a very weird thing that we discuss this stupid bullet all the time, but
Right.
but not. I
Well, but
I don't
so
know.
if a person confesses, that's what corpus delicti.
Oh, well, see, now you reminded me. This is what. Let me ask you this: what do you think, as far as, what does a confession mean when your plea is not guilty? Like, that seems to be in conflict as well. Like, the official stance is what Rick Allen is saying is that he didn't do it and he's not guilty. So you might have unofficial statements that said he did something, but like the official statement is that he didn't do it.
Okay.
There's no official or unofficial admissions.
Well,
Yeah.
I mean, a plea is official. That's the definition of official. You officially plead guilty or not guilty, so that's as official as it gets.
What's guilty or not guilty under the law.
It's also not.
The plea. All the plea does is determine whether the state's got to meet its burden on guilt, innocence, or if they can move straight to punishment. So, the plea is entered in front of the jury, and to that charge. Sometimes they have the defendant say it. Sometimes they have us say it on behalf of the defendant. Sometimes the judge announces the defendant has pled guilty to, not guilty to all charges. Then they're read some preliminary instructions, but the plea of not guilty doesn't lessen anything or heighten anything that the state has to do in terms of proving guilt or innocence. What it does go to is if someone comes in and confesses, and we had a horrible murder case in Austin, the yogurt shop murders, you can Google it.
Oh, yeah.
And 3 young ladies working at a yogurt shop after closing, they're murdered, and then the perpetrator or perpetrators set the yogurt shop on fire. And so there was little or no forensic evidence at all. And so there were, and they charged that as a death penalty case. And not one, not two, but maybe even 3 people came in and confessed to that thing. Waived an attorney. Yeah, I did it. Basically recited facts that they got from newspaper, nothing that only the killer would know that they had withheld. And, they were just nuts. And so somebody can confess to a murder, but they can't be charged under corpus delicti unless there's some corroborating evidence. And this thing's kind of unusual because, and I haven't read the PCA, but I've heard a number of people, credible people, talk about it. And, they talk about this unspent shell casing, tool marks coming back as a positive match. And then they also talk about in the 48 to 72 hours that they're preparing the probable cause affidavit, and they didn't know that they were going to get this, I presume. Then he calls his wife or other loved one and apparently says some things, and then they throw that into the probable cause affidavit, whereas all they would have had, again, I haven't read the PCA, but the main two things everybody mentions is the tool marks from the unspent shell casing and the telephone call confession admissions. Not much beyond that.
In the PCA.
And what's that?
The confessions are not in the PCA.
Where did that come from?
The
The
confessions
confessions all come later.
in, I forget what motion it was in, but it was in the April when they talked about Richard Allen confessing over the phone calls. But
The first time that we got to know anything about these confessions, Travis, is that hearing that we read the transcript for on Saturday. That was the first time we knew anything about a confession or any type of
Right. So that was in June, but you guys have been talking about 2 phone calls with his wife.
That comes out in the filing, yes. So in that hearing, they are discussing those phone calls as well as other things we didn't know about at the time. So we didn't have context to them. But there is a filing done by McClelland where he says, it actually comes up in 2 filings. One, he says that he confessed to his wife on the phone no less than 5 times. No less than 5 times, and he goes into this detail, and then he right underneath it just says, and he confessed to his mother. And that was just kind of it.
And then
into detail
recently,
without
the companions, the
right.
30 statements.
That's all new.
Yeah. So the tool mark evidence, that would be corroboration. So that's interesting. I was always under the impression that they had tool marks plus his
confessions. No, the confessions came after. He confessed to her in April. Maybe that's what you're thinking about, catastrophe, because supposedly it was April 3rd.
Yeah.
And then he doesn't talk on the phone again for I don't know.
That's when they filed the emergency motion to have the safekeeping hearing.
We also know that there's motions to suppress for statements made while under interrogation.
Right.
Yeah.
So, but
I still don't think the ones from the 26th, I think they'd be in the PCA because they don't actually charge him until the 28th. So there'd be no reason if he actually confessed in that 26th interrogation / interview.
I don't think it's.
I think that they just.
I think it has to do with the clothing. You have that same type of clothing, and I think it has to do with he says.
Well, even though that's not really anything, but just the fact that he was there, and they're trying to make the state work for it. You know what I mean? Even if it's a fact of when he was there, the state still has to prove it.
So if you boil it down, I think that the common denominator on most things that the defense really goes after is gun and bullet, because once the motion in eliminate on ballistics is denied, there's no way. If it's coming in, then you have to attack it at every point other point that it's coming in. That's why there's so much focus on the Franks, because that's how they got his gun. That's why there's focus on statements of I had this gun in. So they have to go after the statements. Anything that relates to the gun and the bullet, they're going to go after, just because that's the backbone of the state's case.
No, it's the witnesses too. The nonsense of witnesses.
Yeah, but I mean those
even
aren't
though
very
it's a
good.
joke. Yeah.
I mean the bullet's not good either. None of it's really good, but.
Yeah.
All right. So let me go back. I know I read this when it very first came out back in January, but obviously it's been a little while. So this is Kara's blog. And I think this is the conversation in the live that Travis is talking about where we discussed this. So she says, in Indiana, we have both knowing and intentional murder and felony murder. Unlike other states, Indiana, which I hate this, by the way. I think I already said that, but I'm going to repeat myself. Indiana treats these 2 types of murder the same. They are defined under the same statute and carry the same potential penalties, which is 45 to 65 years in prison. Subsection 1 of Indiana's murder statute is murder as most people commonly know it, the knowing or intentional killing of another person. Allen was not originally charged with knowing intentional murder. Rather, he was originally charged under subsection 2 of the murder statute. To prove felony murder under that subsection, the state must prove that a defendant killed another person while committing or attempting to commit one of the enumerated offenses. Kidnapping is one of those offenses. The original 2 charges against Allen that were filed in late October of 2022 were for the felony murder of victims 1 and victim 2, where the underlying felony was kidnapping. To obtain a conviction for felony murder, the prosecutor does not have to prove that the defendant knowingly or intentionally killed the victim he kidnapped. Rather, the prosecutor need only prove that the defendant knowingly kidnapped or attempted to kidnap the victim, and that during that kidnapping or attempted kidnapping, the victim died. Essentially, the intent to commit the kidnapping is also used to satisfy the intent to commit the murder. In the amended charges, the Carroll County prosecutor added a statutory citation to original counts 1 and 2. Under Indiana law, a defendant can be guilty of a crime under 2 theories of liability. This is what you're talking about, Fiend. The 2 theories: principal liability and accomplice liability, right? That's what you were adding about how they added that on. One is liable as a principal if he himself committed the offense in question. Under Indiana Code section blah, 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 one is guilty as an accomplice if he knowingly or intentionally aided, induced, or caused another person to commit that offense, regardless of whether that person has been prosecuted, convicted, or acquitted of that offense. The amended charging information for counts 1 and 2 merely adds the theory of accomplice liability to original felony murder counts. This is a theory of liability, not an essential element of a criminal offense. So it does not need to be added to the charging information. When the original charges of felony murder were filed against Richard Allen under Indiana law, he could be prosecuted for those offenses as either the principal or as the accomplice. So now to counts 3 through 6. Obviously, she hasn't taken off the kidnapping yet, so we'll go through that part of the amended charging information are new. Counts 3 and 4 allege that Richard Allen knowingly or intentionally killed victims 1 and 2. These 2 counts also include a citation of Indiana's accomplice liability statute. So Allen could be found guilty of these offenses if he's proven to be the actual killer or merely an accomplice to the actual killer. Counts 5 and 6, like I said, we don't that one doesn't matter because they got rid of those anyway. On the original counts of felony murder, the state was required to prove both the kidnapping and the killing in order to carry its burden under the felony murder statute. And the prosecutor is not required to plead accomplice liability in the charging information. So why the amended charges? One could really only speculate. But based on my criminal law experience, there are a few possibilities. First, the kidnapping counts. Once again, those are gone anyway. Absence. Okay, so without the amended charges, theoretically, the jury could find that Allen kidnapped the victims but played no role in the murder. Okay. Absent 5 and 6, Allen would walk free. The state could be increasing its chances of getting some convictions rather than not all. We don't need those. As for the murder counts themselves, this is more puzzling. One idea is to increase the maximum possible sentence Allen could receive if convicted. By separating the murder and the kidnapping of each victim into 2 separate counts, the 2 counts for each victim could be stacked or run consecutively. Instead of a maximum possible sentence of 65 years for felony murder, Allen could face up to 81 years in prison. Amending the charging information for this reason seems implausible. However, Allen is facing 45 to 65 years for each victim. If he is convicted of felony murder, that's 90 to 130 years in prison. As the trial court could stack the sentences since there are 2 victims, given Allen's age, this is de facto life sentence. Seeking a longer sentence is pointless. Many have theorized this request to amend the charging information was done to file a notice of intent to seek the death penalty. This too, unlikely. To seek the death penalty in Indiana, a prosecutor must allege and prove the existence of these aggravating circumstances. The existence of at least one aggravating circumstance has been present since the inception of this case. If the state intended to seek the death penalty, why now and not earlier? Thus, the theory seems far-fetched. The timing of the filing would certainly raise suspicion. Plus, if the prosecutor wished to seek the death penalty, he likely would have filed a notice of intent. My best guess as to why the amendment: these charges likely should have been filed at the beginning of the case, and this amendment corrects that oversight.
Yeah, remember that. Now with this thing being continued, the state can come in and probably has time to file a notice of intent to seek the death penalty.
You think that they're going to now?
I have no idea. I have
really
no
don't.
explanation why they didn't from the get-go. Like she says in there, why didn't they do it? And I was massively surprised. And people's response was, well, we don't really go after the death penalty. And I'm thinking, you're not going after the death penalty. You don't go after the death penalty because you're going to go to trial. You file intent to seek the death penalty to force the defendant to enter a plea.
That was the thought when they had the new attorneys, because they figured that might make his new attorneys want to plead before Rosie and Baldwin got put back on, right? That was the thought.
They're not going death penalty.
No. But that Nick filed that to be able to hold something over Scribato and say, like, hey, like, we're gonna do death penalty. You want to plead because it wasn't Rosie and Baldwin.
I don't even think that the Labrato and Scremin would have been able to oversee the case on the death penalty case. I just think they would have to have been removed as well.
No, he
they,
was.
They weren't qualified.
No, yeah, Scribato. I don't know which one it is, but one of them is.
Their couple name. I love
He
that.
says in the interview for Court TV that he's done death penalty cases and he's never seen anybody held like this.
Gotcha.
DB says, and you also have to pay the attorneys the proper rate from the inception of this case, like the attorneys get paid anyway. He's funny.
Nobody's getting paid.
Nobody's getting paid anyway. Let's be
here?
real here. All right, you guys. I love each of you guys. My dinner is now cooked. My husband gave me the side eye of I finished dinner because you didn't.
Can I ask you one quick question, T?
Of course you can.
If you co-owned a channel with someone and they kicked you off your channel and changed your password, is there any way to get it back?
Yeah, you start tweeting YouTube.
Okay, that's the answer.
Thank you, T, so much for having us. And
oh my gosh, no, thank you guys so much. Thank you guys for coming up and just chatting, and thank you guys for the read through. And Sleuthy, if you're here,
man, I could have been 1,000 other places right now.
You could have been. I know you guys have 1,000 other places you could spend your time, and yet for some odd reason you choose to spend your time here with me, and I can't.
I've been kicked out of 995 of them.
Right.
No, but for real, yeah. Bean, that would be my suggestion, is to start tweeting to YouTube. As long as you can prove that the channel was created by you or whomever, you'd have to be able to show that, I would assume. Gotcha. And then see what they say. But the only way to really get a hold of YouTube, if you're not a huge creator, is on Twitter. It's the only place I've ever found that they listen.
Gotcha.
So, all right, you guys, go have a good night. I'm gonna go eat some dinner that I didn't have to.
Thanks everybody on the panel now and earlier. Good seeing you.
Thanks, Travis.
Bye, guys.
Do you dare to follow me down? Head into the unknown. Down the rabbit hole. Where it stops, no